State your name again for the record.
Dr. L. Jerome Oziel.
I'll remind you, you're still under oath, and Mr. Burt, you may continue your recross examination.
Thank you. Dr. Oziel, yesterday you testified that you had 3 explanations for why you recorded the October 31st and November 2nd sessions on a tape recorded cassette. Do you recall that testimony?
I recall that I stated that, yes.
All right. And your 3 explanations were that, number 1, that it was important for you to get the details for therapy purposes, correct?
That's one.
And the second one was you wanted to document your actions, I think is the way you phrased it. Do you recall that?
I don't recall if I phrased it that way, but that sounds correct.
What did you mean by that, document your actions?
Just document what happened and what steps I took in terms of dealing with the situation.
For what purpose?
For the purpose of keeping notes of what transpired in the session, what was said, and how I responded to it in my role.
And the third explanation you gave was that it was important for you to get the documents in a safe place. Do you remember that?
I do.
All right. Now, were there also 2 other reasons why you made the tape recording?
I don't know what you're referring to.
Well, did you make the tape recording for the purpose of creating a false record so that you could use the tape to extort money out of the Menendez brothers?
No, Mr. Bird, I did not.
And did you also create a false tape in the sense that you had false information on that tape for the purpose of using the information on that tape to control your wife and your girlfriend?
No, Mr. Bird, I did not.
Now, you testified, I think, under oath in cross-examination with Ms. Abramson. As follows at page 9869, which is volume 63. Sure. Line 17. Yes. Remember Dr. Oziel testifying, question, and isn't it true that over the course of your relationship with Ms. Smith, you frequently threatened her to control her behavior by telling her, aha, I'm going to tell Eric and Lyle that you know their secret and they'll come kill you. Didn't you do that? And your answer, quite to the contrary. Remember that?
Seems like what I testified to, yes.
And is that still your testimony? That is that you did not use the Menendez brothers to threaten and control Judalon Smith?
It would be my testimony that that's absolutely true. At the time that she was threatening to turn in the tapes or disclose to the police about the existence of the tapes, I definitely told her that I thought that that was an error. And I told her that if she turned in the tapes, I was concerned that both her life and my life and the lives of my family would be at peril. So if that's what you're relating to, I definitely told her that throughout that period of time.
Well, was there a period of time where you were telling her that you were going to leave messages for Lyle to come and kill her?
Absolutely not.
You sure of that?
To leave messages for Lyle to come and kill her?
Right.
No, I didn't.
Right. Do you remember an occasion between October 1989 and March 1990 where you and Miss Smith were in her bedroom and you were singing some songs to her in an Elvis Presley imitation voice?
No, I do not.
Do you remember Miss Smith saying to you, in answer to your question, well, who'd you think it came from, Elvis Presley? And Miss Smith saying, yeah, I'm going to write the Inquirer and tell them. And you said that Elvis is alive and singing songs in my bedroom, that's good. They'll put you away in the loony bin for sure. and Smith saying, I'll send them a videotape, and you saying, yeah, right, I'll kill you, or I'll just leave a message for Lyle. Do you remember making that statement?
No, I don't. But if I did, it would have been a joke, but I don't remember making it at all.
So you didn't make it, but if you did make it, it was a joke, is your answer.
No, my answer is I don't recall any of that conversation, but I definitely wouldn't ever have said anything like that had I ever said something like that and meant it seriously. But I don't recall anything having to do with that conversation.
So again, your answer is twofold. You didn't say it, but if you did say it, it was a joke.
Objection, this takes testimony.
Sustained.
Did you make that statement over the telephone
I don't recall having made that statement at all.
in any way, shape, or
No,
form?
I could have made it on the telephone. I mean, if I could have, I don't know if the statement is there somewhere, then I don't recall it.
In other words, if there's a tape recording with your voice on it, would you agree that you made the statement?
I'd have to hear it, Mr. Burt.
Well, if someone who's familiar with your voice listened to the tape recording and testified to the circumstances under which that tape was made and said, this is Dr. Oziel's voice, would you accept that, or would you say, I never made that statement under any circumstances?
Objection, calls for speculation.
Sustained.
Is it your testimony that under no circumstances did you make that statement?
It's my test. I'm sorry.
Objection, this takes testimony. Counsel.
Sustained.
Now, Dr. Oziel, I think you testified yesterday that on March 8th, you still believe that the Menendez brothers posed a threat to you. Is that correct?
That's correct.
And on that date, did you tell the police who were serving the search warrant at your house that you were the only one threatened by the Menendez brothers?
I don't recall.
If you did say that, was that a true statement?
I think what I was feeling at the moment was that I particularly would be a target. And I don't recall having said it, so I can't speculate as to what I said or why I would have said it. But I can recall that my feeling was that if, in fact, Lyle and Eric felt that I voluntarily turned in the tapes, and they perceived that as a betrayal in the sense that I voluntarily turned them over to the police, that they specifically at that point would have been targeting me and not anyone else.
Well,
I move to strike the answers and not respond.
I join.
Objection sustained. The answer is stricken.
My question is,
Anytime something is stricken, ladies and gentlemen, you are to disregard it, whether it's now or any other time.
Dr. Oziel, let me re-ask the question, which was, if you said to the police on March 8th, 1989, that you were the only one threatened, if you made that statement, was that a true statement?
At that moment, that may have been what I was feeling, and that may have been a true reflection of my feeling at that moment in relationship to the tapes being turned over.
All right. And so would it be fair to say, based on what you just said, that at that moment, that is March 8th, that Miss Smith was no longer in danger?
No, I wouldn't state that.
You wouldn't.
No.
If the statement was, I'm the only one who's in danger, if you made that statement, that would be a true reflection of your feelings, but that would also somehow include Miss Smith in that statement?
No, I think at the moment that that I made the statement, that was my feeling. And so, I mean, if I made that statement, then that must have been my feeling at the moment. I'm not.
And is it your testimony that the next moment, literally the next second, your feelings changed and it was not only you that was threatened, but also somebody else?
I can't really document from moment to moment how my feelings changed 4 years ago. I can tell you that my primary concern at the moment that the police seized the tapes that I had been trying to protect and keep in a safe deposit box and not to turn over to anyone, was that the Lyle and Eric would conclude that I had turned in the tapes voluntarily to the police, which all along is what I had labored to not do.
All right. So is your answer that your feelings from moment to moment as to who was threatened was changing on March 19th?
I think
Excuse me, on March 8th.
Yeah, I think my testimony would be at that moment, I was in a state of a lot of concern and a lot of fear. And I don't recall what my feelings were from moment to moment 4 years ago. I only recall that I definitely had a significant level of fear at the moment that the police and a number of other people were in my house with a search warrant seizing the materials that I had tried hard to protect and keep secreted all that time.
And were you trying hard on that date, that is March 8th, to keep them secret and protected so that no one else could listen to the October 31st, November 2nd tape?
Yes, I was.
And did you volunteer to anyone that they listened to that particular tape?
No, actually, it was quite the contrary.
In other words, at no point in time did you say to the police, listen to the October 31st, November 2nd tape, or words to that effect?
No, I didn't state that. What occurred is that the police demanded that I play the tapes.
All right, the objection is sustained. The answer no will stand. The rest of the answer is stricken.
Did you volunteer that the police listen to the October 31st, November 2nd tape on March 8th?
Objection irrelevant.
Overruled.
No, I did not volunteer it.
Fine. And on that date, is it true that if you made a statement that I'm the only one threatened, that that statement may not have been accurate as to other moments, other than the moment that you were making that statement?
It may not have been a complete and accurate statement in the midst of my being very fearful about what was going to immediately happen. It was my feeling is what I was stating.
All right, so it could be you didn't make the statement. If you did make the statement, it only reflected your thoughts at that moment. And if it didn't reflect your thoughts at that moment, then you were fearful, and that's maybe why you made the statement. Would that be a fair summary of all your explanations for that?
I don't know if that's a fair summary or not.
Well, after the emotion of the moment went by on March 8th and the police left your house, did you still think that you were in fear of the Menendez brothers?
Yes.
And did there come a time on or about March 8th, 1990, when you learned that Lyle Menendez had been arrested?
I don't recall when I learned that Lyle had been arrested.
And did you learn at some point that Eric had been arrested?
At some point.
Was that shortly after the police served a search warrant at your home?
I don't recall the time period, but sometime afterwards, yes.
And when you say sometimes, I'm not trying to pin you down to a date, but would you say a couple of days as opposed to maybe 2 weeks later?
I don't recall when they were arrested. I couldn't tell you if it was 2 days or a week. I don't recall.
Did you, after they were arrested, think that you were still in danger of them coming over to your house and killing you after they were in custody?
No, I didn't think that I was in danger of them coming over to my house and killing me.
Did you think Miss Smith was in danger after they were arrested?
Potentially in some danger.
How did you think she was in danger?
Well, the police had told me,
Overruled.
the police had told me that that it was possible that even if the Menendezes were not themselves free, that there were still ways that that I could be harmed, or that that I could be harmed. And I construed that if there were ways that I could be harmed, then maybe there were ways that other people could be harmed.
They didn't specify, though, how that could take place, correct?
Yes, they specified that it could be arranged.
Did they say how it could be arranged?
I don't recall the specifics of it. They simply led me to believe that there were still possibilities. That, as a matter of fact, all I recall is that they led me to believe that there was that possibility.
Did you think the police were maybe threatening you at that point, in addition to the Menendez brothers, by telling you that information?
No, I didn't think that.
And did you think that it was your duty to warn Miss Smith that there were still some dangers lurking in the background at that point after they were arrested?
I don't recall my feeling at that particular moment.
It was at that point in your relationship, I think, that you said that you had made a decision to break off with Miss Smith. Isn't that true?
I think that I had already broken off with Miss Smith.
It was already over, the relationship, correct?
To the best of my belief.
And if I understand your testimony yesterday, there was this long period of obsessive concentration on you by her. And then there was a period right around March 8th where you had a concern for her because she disappeared, right?
Yes, that's correct.
And you said the phone messages which we played for you were a distortion of whether you were fixated on her, because it really only reflected your fixation on her at that moment at a point in time when you were concerned for her safety. Would that be a fair summary of your explanation for that?
Objection, asked and answered.
Overruled, since this was covered by the prosecution on redirect.
I don't even recall the question, Mr. Burt. Could you repeat it?
Yes, I could repeat it. Would it be a fair summary to say that your relationship with Ms. Smith was characterized by a period of time between the time you met her, I think you said in June, until March or around in there, where she was fixated on you and pursuing you, and you were attempting to get away from her? Let's take that part of it first. Would that be a fair summary of the period of time from the time you met her up until the phone messages, which we're going to talk about in a moment?
No, that would be a misstatement of my testimony
And how would it be a misstatement?
in a number of ways.
Well, did you testify that during that period of time she was pursuing you and you were trying to get away from her?
No, I didn't say I was trying to get away from her.
Pardon?
I didn't say I was trying to get away from her.
But there was a period of time, and I think you testified your reason for revealing to her the content of the October 31st and November 2nd session was because at that point in time, she was in a relationship with you where she was compulsively fixated on you.
All right, I'm going to sustain the objection as to asked and answered because the area covered by the prosecution related to the answering machine tape, and
All right.
counsel will have to confine his examination to that area.
Is it fair to say, Doctor, that with reference to those answering machine tapes, that you said that your voice on those tapes and the repetitive nature of you calling her up did not really reflect any fixation by you, because it really reflected a special situation where you thought she was in danger and that's why you had to keep calling her?
I did testify that those tapes that you played were not representative of the content or the kind of process that took place in an ongoing way in the relationship. Yes, that's true.
And would it be fair to say that you had not been compulsively calling her up to that point in time?
No, I think I testified that our agreement was that she wasn't able to call me at my home, and she also was not able to call me at my office. And so the agreement was, and her request was, that I call her very frequently. And I think I testified to all of that previously.
And you said you were concerned for her, and that's why you kept calling her only that one day.
I don't think I said that I only called her that one day at all. I think that it's already been established that there were many phone calls to her, and in fact, they were at her request, and also they were the only vehicle through which we could communicate, and she wanted me to call her very frequently, and in fact, got very upset and very insecure when I didn't call her frequently.
All right,
Very demanding.
And after you placed those phone calls, which the jury's heard, is that when you broke off the relationship and said, I can't any longer continue to comply with your wishes for me to come over all the time and call you up and take care of you?
I don't, the relationship, as far as I was concerned, was essentially, for all practical purposes, over long before that, from my standpoint. And the final asking her to leave the home was not the end of the relationship. The relationship, in my mind, had really, for any practical purpose, ended long before that.
All right, the court is going to strike the answer, and again, counsel, the inquiry has to do with the tape recordings, the audio recordings of the answering machine tapes, nothing to do with leaving the home. So let's focus on that time frame, please.
Well, you testified yesterday that Ms. Smith was fixated on you. Do you recall that testimony?
Objection, asked and answered.
Sustained. Let's focus on the area that was covered on redirect.
Well, I'm moving on to a new area that was covered.
All right, well, then let's not regurgitate, go on to the actual question rather than going over the preface.
I was trying to do. Sir, do you recall testifying yesterday that Ms. Smith was pressing you not to be in the marriage?
Yes.
And do you recall you testifying yesterday that you broke off your relationship with her in early March of 1990?
Yes, I did.
All right. And in reference to that statement that you broke off the relationship with her in early 1990, isn't it true that even after the Menendez brothers were arrested, that you continued to pursue her and threaten her with the Menendez brothers?
I don't have any recollection of that and don't know what you're referring to.
Well, do you remember going over to her house? I think you testified in answer to questions by Ms. Abramson in cross-examination that you recall on or about March 19th, 1990, that you went to her house at a time when the police were on the premises and had put a body wire on Ms. Smith. Do you recall that testimony?
Objection, the end is still redirect.
It is. Objection sustained.
Could I put your bench on?
Yes.
Thank you. Dr. Oziel, getting back to the subject here, do you remember going after the police served a search warrant on your home on March 8th? Do you remember after that point in time, and specifically on March 19th, going over to Ms. Smith's house to bring some of her belongings back to her?
Oh, that's correct.
And was that on or about March 19th?
I believe it was, yes.
And did you later learn through review of some documents that she had been, to use the phrase, wired for sound, and that the police had actually been in her house tape recording your conversation with her?
That's correct.
All right. And you've reviewed the transcript of those tapes or listened to the tapes, have you not?
If I did, it was 4 years ago. I haven't listened to them since.
And do you remember when you went to her house on March 19th, the first thing that you did was to try and embrace Judalon Smith, and she said, "I don't want any hugs." And you said, "You don't feel like hugs?" And she said, "No." Do you remember that?
No, I don't, but that could have happened.
And do you remember one of the next things you said after you were talking to her was you said, "Well, first thing we have to establish is what kind of relationship do we have here, because you have not been acting like a friend." Do you remember saying that?
Yes, I probably did say something. I don't remember it, but I probably did say something like that.
And your statement that she had not been acting like a friend was in reference to her going to the police about the tape. Isn't that true?
No, it was in reference to things that she had been doing over a long period of time that were, I thought, extremely vindictive and vicious, and did not only relate to her going to the police.
And when you said, well, the first thing we have to establish is what kind of relationship do we have here, because you have not been acting like a friend, is it true that the following exchange took place? Smith, Jerry, that is not the first thing we have to establish. And you then break in, that's the first thing I have to establish because you've been behaving really, just really. And Smith breaks in and says, "You mean there are other people out there who would want to kill me and you're not going to tell me that?" And you say, "They probably want to kill me too. And you fell into this fix by what you did." And Smith says, "Why? Why?" And you say, "I tried to tell you that and you wouldn't listen to me. I tried to tell you that you didn't know half the story and you don't." Smith then says, "Well, maybe you should tell me so I can do know something, so I cannot do something stupid." And you say, "You already did something really stupid, really, really stupid." And she then says, "Well, the boys are in jail and I'm not dead. And you said that if I went to the police, I'd be dead in 2 minutes." And your answer was, "Guess what? It's going to be a little bit longer." Do you remember making that statement?
Objection, hearsay.
Overruled.
I don't remember making the statement.
You don't remember making it.
I don't remember the specifics of that interaction. They might have taken place.
And so you might have said to her that, guess what, it's going to take a little bit longer, in reference to she's not dead yet.
Well, what I was saying is that I perceive that there is still a threat to her and to me.
And you were doing that for the purpose of manipulating her back into the relationship. Isn't that true?
That's absolutely false. I was expressing anger at her putting us,
Objection overruled.
I was expressing anger towards her for putting myself, my wife, my children, and I perceived her in jeopardy. And as I already testified, the police had told me,
Objection, Your Honor.
I'm explaining why I made that comment,
You may finish your answer.
that the police had already told me that the fact that the Menendez brothers were in jail was not a guarantee of any kind of my safety. And in fact, I had been told that by numerous parties associated with the police department. And so my feeling of threat did not terminate at all with the arrest of Eric and Lyle. And I was expressing to Judalon Smith my anger at her having done this. She had been threatening to do it as a way of trying to get me to be with her. Specifically, she was threatening that if I didn't stay in the relationship with her, she would use the fact of her knowledge about the Menendez case, and she would go to the police. And then subsequently, as I've already testified, she signed a document.
Your Honor, I do think this is getting.
I'm explaining.
Yes, you've gone beyond the
Okay.
question at this point. All right, your next question, please.
And do you remember Dr. Oziel in that same conversation telling her that I received anonymous clear threats from people that related to my life and had to do with me turning people in and had to do with me handling these tapes over. I said I did not hand the tapes over, and they were very clear references that when they found out who did hand the tapes over, that that person would pay and that would be that for them.
Yes, I did.
Remember saying that?
Yes, I do.
And is it true that throughout this entire conversation, you kept making reference to people threatening the two of you
People did threaten me.
and connected with the Menendez brothers, according to you?
I did receive threats connected with the Menendez brothers, and it was reported to the police.
And was this meeting on March 19th something that you felt you had to do because she was again bothering you in the period between March 8th on or about the time when you broke the relationship off and the period of time when you had this meeting?
Yes, she was.
She had insisted that you come over on March 19th.
She had asked for me to come over March 19th, but it went beyond that. She was using other means of what I perceived to be extortion at that time.
Was she insisting when you walked in the door that you try and hug her and say that the first thing you wanted to talk about was your relationship?
No, what I was trying to establish is whether, in fact, there was any basis upon which I could trust anything she said. And I think that the entirety of that conversation will indicate that I revealed nothing about the Menendezes, disclosed nothing of content about Eric or Lyle, refused to talk about Eric or Lyle, refused to discuss any details throughout the conversation, having had no idea that she was wired about Eric or Lyle, said that I would not perjure myself at all, and refused to do anything but tell the truth under testimony. I think if you read the entirety of that police wiring, Mr. Burt, you would find that there were dozens and dozens of comments that related to the fact that everything I was going to say, if I was ever called upon to testify, was going to be the truth and only the truth, and that I refused to perjure myself. I don't think you read that part, Mr. Burt.
All right.
I'd like to move to strike the answer. This witness is becoming.
Okay, counsel, let's not make a speech. If you have an objection, the objection is a legal grounds.
Not responsive.
All right, let's have the question, and what?
Multiple levels of piercing.
All right, let's have the question reread, please.
Question, all right, was she insisting when you walked in the door that you try and hug her and say that the first thing you want to talk about was your relationship?
All right, the objection is sustained. The answer is stricken, and you may answer the question.
No.
Doctor, is it also your testimony that you were not making the November 2nd, October 31st session in order to extort money from the Menendez brothers?
Absolutely.
And during this session on March 19th, do you recall you saying to Judalon Smith, Judalon, I'm trying to help you. I'm the only friend you have, You're not making it easy. I'm trying to help you. There's nobody else that cares about you. You're in trouble. I'm trying to help you. And Smith saying, Jerry, the boys did that by themselves. And you saying, Judalon, you don't know what you're talking about, and I can't tell you anymore. I tried to tell you before. If you want to believe that, then I'll just get out of here and leave you be and let you do what you want, okay? You're not going to know. There was $14 million involved in this. Do you remember saying that?
On which date?
March 19th?
I don't recall it.
Well, do you remember a statement specifically in reference to your saying there was $14 million involved in this?
No, I don't recall that specific statement.
Do you remember at the time you made the October 31st or November 2nd tape that it was your understanding that the Menendez estate was worth approximately $14 million?
I don't recall making the statement, but I might have made the statement. I don't recall it.
Objection not responsive.
Objection sustained. The answer is straight. Are you asking when he tape recorded his notes, or are you asking when the conversations on October 31st, November 2nd occurred?
The question was in reference to the time when you taped the notes.
When I taped the notes, the best of my recollection is that I stated that that's what Eric's statement was about the worth of the family estate.
So you had information from Eric that that's how much money was involved.
That's what Eric had told me.
And in general, would it be true that if you were making a tape for purposes of extortion, that the more harmful the tape, the better device it would be to use for extortion?
There's your cause of speculation.
Sustained.
You testified that at one point in the November 2nd or October 31st session, you offered two scenarios of different crimes.
That's correct, Mr. Bird.
And would it be fair to say that of those two scenarios, the one that you described as a premeditated murder scenario was, at least in your mind, the more damaging of the two in terms of incriminating them?
Objection beyond the scope.
Objection sustained.
Now, Doctor, you testified yesterday with reference to the packet of letters. I don't have the exhibit in court, but do you recall testimony about a letter that Judalon Smith sent to you that reflected what her solicitation of your business?
I recall that letter. Something
Approach
about the letter.
witness, Your Honor.
Yes.
Is this a copy of the letter dated June 15th, 1989?
Yes, it is.
And I'm not sure what exhibit number that is, Your Honor, but the court reporter has it.
It's exhibit 120.
Thank you. That letter is dated June 15th, 1989, correct?
That's correct.
And is it your testimony that that was the first communication you had with Judalon Smith?
No, it isn't.
What was the first communication in terms of date?
Well, according to Judalon Smith, it occurred.
Objection on hearsay.
May I have the question read back, please?
Question, what was the first communication in terms of time?
All right. Do you have a recollection of that, of your own memory?
Not of my own memory, only
Right.
from a note from Judalon Smith.
All right. The objection is sustained at this point.
Can you use the note to refresh your own memory as opposed to just telling us what Judalon Smith says?
No, I can't.
Right, this you received on or about June 15th, 89?
That's correct.
And do you recall having any substantial dealing with her before June 15th?
Yes, I do.
And was that by way of phone or in-person meetings? What was it?
I think there were a large number of phone conversations beginning several weeks or so before that.
So maybe from the 1st of June onward, or was it even before that?
Could have been before the 1st of June. I don't recall.
Was there any business dealings that you two had before this letter was sent on June 15th, 89?
Well, yes, there were.
What?
Well, Judalon Smith had broached the topic and made business propositions from the first phone call that she made. That was the point of the phone call. And subsequent to that, we had a number of conversations, and I don't remember the exact dates of them, but the conversations did in fact deal with business and business propositions and tape duplication and so on and so forth.
But was that just preliminary discussion, preliminary to this, what you characterize as her letter of June 15th, which basically formalized the business relationship?
No, I wouldn't state that. I would state that this letter was the first written solicitation letter, but it wasn't her first solicitation. She had solicited me for business purposes prior to that, perhaps as early as several weeks or so prior to that.
And had you come to any formal understanding with her, written or otherwise?
I don't know if it was a formal understanding. I think we discussed back and forth that she wanted to duplicate materials in my clinic, and she basically wanted to do this line of tapes. And so we had discussed it and the conditions under which that would have to take place. If it took place, so on and so forth, it would have to be confidential. She told me all about the FBI and all about her having done work, I think, also for the district attorney's office, and that everything that she did was strictly confidential, and she was used to working with confidential situations like therapy situations. And to the best of my recollection, all that took place before, and it may have also taken place to some extent after this June 15th letter.
And is it true that the June 15th letter then prompted you into a more formalized business relationship with her?
Well, no, that wouldn't be a fair statement, that alone prompted me into a more formal business relationship with her.
Well, when after this did you enter into a formal agreement with her where she was going to be duplicating your tapes?
As far as I know, I mean, it could have been any time from the first conversation to which we had, which would, prior to June 1st, whatever. I don't know what the date is. I don't recall it. In an ongoing way. She had been approaching me, and we had been.
I'm going to object at this point. The question was.
Counsel, if you have an objection, again, state the legal
Not
grounds.
responsive.
Let's have the question read back.
Question, well, when after that did you enter into a formal agreement with her where she was going to be duplicating your tapes?
All right, do you know when it was?
I don't recall a specific. I don't think there was a specific day. I think it was an evolutionary discussion.
Okay.
So you didn't mean to imply by reference to this letter in your redirect examination that this somehow was the first letter that prompted the whole relationship between the two of you?
No, I didn't. I meant it was only a written evidence of her soliciting me.
And in fact, there were dealings you had with her prior.
Yes, there were.
In fact, the confidentiality agreement, which is Exhibit 101, that's dated June 1st, 1989.
Yes, it is.
And did you date that document, or did she?
No, she did.
And was that an accurate statement as to when you entered into a confidentiality agreement with her?
I have no idea. She filled this out and she signed it and dated it, so I wouldn't have any idea at all whether that was accurate or not. You'd have to ask her.
So there may have been, and appears from that document to have been some discussions prior to that letter of June 15th, 1989. Is that correct?
There were discussions, and I don't recall when she signed this document at all. It's her handwriting, her signature, and her dating.
Now, was the only reason you told Judalon Smith of the content of the October 31st and November 2nd session because you thought she was in danger?
I believe that was the primary basis. I also perceived at that time, because of the confidentiality agreement we had orally, and also this confidentiality agreement, that she was someone that I could disclose that information to, who would keep it confidential, which she obviously didn't. But the primary reason, and the reason that I disclosed it to her, was because I thought that she was in harm's way.
All right. And you would not otherwise have been disclosing what you considered to be confidential information to a non-confidential person?
No, I would not have.
You just don't do that as part of your practice?
Objection irrelevant.
Sustained.
You said that the information recorded on that tape of recording the sessions of October 31st, November 2nd did not contain inaccurate information, correct?
I don't believe that I stated that.
Well, let me ask you, did the tape of your notes contain inaccurate information?
I don't have any idea if there's some word or some statement somewhere that is inaccurate in the entire 20 pages of typewritten notes.
Well, were you intentionally trying to record inaccurate or false information, as I asked you before?
No, I absolutely was not intentionally trying to record anything, and I'm not aware of anything that's inaccurate, but that's not what you asked me.
And is what you told Smith based on what was in the notes?
To the best of my recollection, what I told Smith would have been a summary of things that I thought were important for her to know, for her to have enough information to appreciate the level of danger of the situation so she could make her own decision about what to do.
So the answer is that what you were telling her was basically what was reflected in your notes.
To the best of my recollection.
And I want to return, if I could, to an exhibit. I believe it's.
May we approach, please?
Yes.
Dr. Oziel, in reference to your testimony yesterday that Judalon Smith was fixated on you, was there a point in time when you took the shotgun away from her?
Yes, there was.
And why
Or
did
she gave it to me. I don't remember if I took it away or if she gave it to me.
why did you do that?
I don't recall I don't know how it came about that I got the shotgun back. She may have given it to me. I don't recall.
Oh, do you remember on March 19th when you two were talking and she said to you, but then you took the shotgun away and you said, excuse me, that's because you were in my house when you and I were talking about going away together and moving somewhere together, okay? You were in absolutely, totally, I believed you to be in danger at that time. Do you remember that statement?
No, I don't remember it. I don't recall it. But if I took the shotgun away, I don't recall when that was. And it probably was because I thought she was in danger of harming herself with the shotgun.
You've just dragged your other speculation. Settled in.
Objection is sustained. The answer is non-responsive. The answer is stricken.
Did you talk to her at some point about going away and moving somewhere together?
Objection beyond the scope.
Can you specify a time frame, please?
But when you spoke to her on March 19th, did you say, when you and I were talking about going away together and moving somewhere?
Objection sustained.
In the period between October 31st, 1989 and March 8th, 1989, did you have a discussion with Judalon Smith where you two were discussing going away and moving together?
There was a discussion, I believe, that we had at one moment where I thought I might have to move away and she wanted to move with me because of the danger.
And I think you said yesterday in your testimony that she was pressing you not to be in your marriage. Is that right?
That's correct.
And do you remember what period of time that pressing took place?
It took place on an extremely regular basis and sometimes on a daily basis.
From the point in time when you first became involved with her up to when?
No, from the point, I can't recall specifics, but I can basically state that from several months after the time that I first met her or talked with her, throughout a lot of the time that there was a relationship, she was pressing me to be with her and not to be with my family. And I was telling her very frequently that that's not what's going to happen.
That was not going to happen. And do you remember during that time period having a telephone conversation with her where she asked you, so how's the discussion going? And you answered, you pressure me every single minute of every single hour. You're so funny. And she says, you decided that before you knew me. And you say, yeah, but I didn't decide to do it like 7 months early because you couldn't stand to be one day without me. Were you speaking about a divorce there? First of all, did you make that statement?
I don't even recall having made it, and no, I don't think I would have been talking about a divorce, but
Do you
I don't
remember-
recall a statement.
Do you remember a statement in that same conversation where you said,
What is the date of this conversation purportedly?
between the period of October 31st and March 1990?
Objection is sustained. It's under section 352 of the evidence code.
Could I approach?
Yes.
Again, Your Honor? Thank you. Dr. Oziel, did you say yesterday that it's your belief now that Judalon Smith was present on November 2nd?
To the best of my recollection, she was present on November 2nd, and she could have been present on a night or one time after that as well. I don't recall, but I do recall that she was, I believe she came November 2nd against my instruction to her.
And did she indicate to you why she was coming?
She indicated why she came.
And what did she say in that regard?
That's in hearsay.
Do we have a foundation as to when this was stated to the witness, please?
Yes. Did you have a conversation with Judalon Smith prior to the November 2nd session?
Well, I had a conversation prior and after the November 2nd session.
Was there a conversation where you two discussed her coming to the office against your advice?
Yes, there was.
Was that an in-person conversation or a telephone conversation?
I don't recall.
Do you recall when it took place?
Just before the session.
That same day.
That's my belief or recollection, yes.
Where were you when you had this conversation?
Probably would have been, I think that whole period of time I was secreted at her house. So I might have been at her house, or I might have been, I don't recall where I was actually, just speculating or trying to guess about where I might have been.
And did you advise her that you didn't want her coming to the session?
I advised her that I thought that it was dangerous and unnecessary for her to come to the, not to the session, to sit in the waiting room. She wasn't coming to the session.
And she said, I don't care, I want to come, or words to that effect.
I don't recall what she said or if she just came.
And did you two then go to your office at some point after that discussion?
Fiction vague.
You're referring now to November the 2nd?
Yes,
When he went to the office on that date?
correct.
Objection overruled.
I don't recall anything about what immediately happened before the session.
Well, you do recall she was there that day.
I have a vague recollection that she was there when I walked out of the session, and that's how I recall that she was there that day. I don't have any specific recollection of anything other than when I walked out of the session, as I recall, she was in the waiting room.
And did you walk out of the session with the Menendez brothers?
I do not recall that. They may have walked out first. I just don't recall. I'd be speculating.
Do you know if she saw them based on your discussions with them? Discussions with her afterwards or that day?
Fiction called for hearsay.
Sustained.
Did you see Judalon Smith in the presence of the Menendez brothers that day?
She was in the waiting room and they walked out. So I'm assuming they could have seen her and she could have seen them. Yes.
Objection, Your Honor, speculation.
Objection sustained. The answer is stricken.
She was in the waiting room when they walked out.
That's correct.
And do you have to go from your office to get out the door? You have to walk by that waiting room.
That's correct.
Was there any shouting during that session of November 2nd?
Not that I recall. No. But I don't recall there being shouting either at the October 31st or November 2nd session.
And based on your knowledge of the way your office is set up, could you hear the content of what was being said between you and Eric and Lyle if you were seated in the waiting room on November 2nd, 1989?
To the best of my belief and my experience, the answer would be no.
And do you remember testifying at page 9871,
Volume
63?
line.
14.
Objection irrelevant.
You're asking a question at 9871, is that right? Line 14.
9871,
You're asking that question of the
lines
witness?
14 through 20.
Objection sustained.
I think you testified yesterday that you looked to see if the Jeep had left when you went back to your office or before you went back up.
No, I didn't testify that. That's not correct.
Did you see both Menendez brothers leave in the Jeep on October 31st?
No, I didn't. I observed the fact that the Jeep was not there at the time the security guard escorted me to my car, and I drove out carefully, and the Jeep was not there.
So you didn't see them leave, is that correct?
I did not.
Now, lastly, Dr. Oziel, you testified yesterday to the fact that you were on probation, correct?
That's correct.
You also testified you were honorably discharged from the Army, was it?
That's correct.
What branch of the Army were you honorably discharged from?
The Army. The Army is a branch of the military services.
That's what it was,
Mr. Burt.
the Army?
Yes,
No,
Mr. Burt.
I apologize. I think my question was, you said you were discharged, but I don't think you said what you were discharged
I
from.
was discharged from the Army.
Thank you. And I think you said yesterday that you were on probation for an incident involving a patient named Court Day. Is that correct?
That's correct.
And you said that Court Day had formed a relationship with you, correct?
That's correct.
And you said that there was no attempt by you to exploit him in any way.
That's correct.
And you also said that you stipulated that what you had done in relation to Court Day was a technical violation, correct?
That's correct. That's how it was characterized to me by the supervisor involved.
And I think when you were testifying in Ms. Abramson's cross-examination, you were explaining how the gist of that violation was what's called a dual relationship.
That's correct.
And I think you also testified that a dual relationship is something that's not favored, but it's not necessarily a serious violation.
No, I think what I said is that the ethical code of the American Psychological Association states that that dual relationships are to be avoided because they have the potential for posing problems for the patient, conflicts of interest, and also give rise to occasions where there could be exploitation. So they are to be avoided. I didn't say that they were unimportant or that it wasn't a mistake to have been involved in that situation with Mr. Day.
And when you say something to be avoided, that's different from saying they're prohibited.
The language in the actual ethical statute at the time that this took place was they are to be avoided whenever possible, not that they are prohibited. to be avoided whenever possible is, as best as I can recall, an exact quote from the ethical code.
And what is your understanding as to why they should be avoided?
I think I just stated that it has to do with the potential for conflicts of interest and countertransference issues. And in addition to that, the potential for there to be exploitation in the relationship.
Well, you said three things. Conflicts of interest. Would you explain what you mean by that?
Well, specifically, if a patient is in a dual relationship, and dual relationships do not only relate to employee, it could relate to treating a relative, it could relate to a number of different kinds of relationships where there simply are two roles that the therapist has with the patient. One being the therapist role, and the second being another role that could bring conflicts of interest into the situation. I don't know how to explain it anymore.
Okay.
than that.
And the other two things you said were exploitation, and what was the third one?
I said what are called countertransference issues.
What does that mean?
It simply means that that the more that a patient's exposed to the therapist outside of the therapy relationship, the more it's easy for a patient to begin to have personal responses to the therapist that have to do with other important relationships in the patient's past, and that can sometimes be problematic in the therapy relationship.
And the third one you said was the exploitation potential. What does that have to do with?
Exploitation just means the possibility or potential for a therapist to take advantage of a patient in some way.
Take advantage how?
It's nothing specific, it's just take advantage.
Well, it could be financially. That would be one way, correct?
Could be anything.
Could be sexual, would be another way.
I think I just said it could be anything.
But it would be anything that basically went beyond the bounds of what the person was properly there for, which is therapy, right?
That would be correct.
Okay. And you said that your understanding was that what you were involved with was a technical violation, correct?
That's-
Sustained. The answer is stricken. Yes.
Showing you exhibits 123 and 124. First of all, with reference to 123, do you recognize that set of documents?
Yes, this looks like the stipulation that related to this incident with Court Day.
Okay. And if you look at the last page, I think there is a document signed by you, is there not?
Yes, there is.
And does that document indicate that you have been provided with a copy of the stipulation and the other documents in the package, and that you've read and understand those documents?
I don't know. To the best of my recollection, I did receive this document at one time, but I don't know about any other documents I received.
Does the last page say, I have fully read and understand the terms of the above stipulation. I fully and freely accept its terms of settlement and hereby waive all rights which may be accorded to me. And then it goes on with some further.
I'm reading over your shoulder.
Yeah.
It appears to say that. It does say that.
It says, I understand that my license as a psychologist is revoked, that the revocation is stayed, that my license is placed on probation for a period of 5 years, and that I must comply with the terms of probation. I further understand that the terms of probation include an actual suspension of 1 month. I also understand that I must comply with the supervision requirements set forth in paragraph XB of the stipulation, and that termination of such supervision is contingent on the taking and passing of the oral examination portion of the licensing examination. And then it's signed Leon Jerome Oziel, PhD, correct?
That's correct.
All right. And then exhibit one, and that set of documents is from the Psychology Examining Committee of the Division of Allied Health Professions.
That's correct.
And exhibit number 124, can you identify that?
Yes, that's the behavioral science examiners. I don't even know that I ever saw this. Did I sign this? No, I didn't sign this. I've never seen this before.
Well, whether you know what it is.
It looks like a stipulation of the same exact decision. They simply have adopted it with the Board of Behavioral Science Examiners. I don't recall I've ever seen this. So
Well, is it true, is it not, that you had, as I think you covered yesterday, two separate licenses? One was your psychology license, and the other was your, what's called an MFCC, which is Marriage, Family, Child Counseling License?
yes, I believe that I testified that they simply work together, and whatever the one board does, that the Board of Behavioral Science Examiners turn this over to the Psychology Board, and then whatever the finding was, they adopted it.
And in reference to the accusation from the Psychology Board, which is Exhibit 123, you'll see attached to 124, is the actual accusation by the Psychology Board, correct?
Correct.
And you've seen this before, have you not?
Maybe the last time I saw that was in 1985 or something of that nature. So I don't think I've seen that for probably 8 years.
And what it says here is that they were charging you with gross negligence, correct?
If you're reading it, if that's what they were charging,
See,
yeah.
take a look and see if that's what the accusation was.
that's a charge.
Okay. And the charge was that on or about June 1981, respondent commenced treating patient in individual therapy. This therapy treatment continued on an irregular basis, some weekly sessions, some marathon sessions on weekends, most sessions at respondent's office in Beverly Hills, but some sessions at respondent's home in Sherman Oaks on weekends until June 1982. During this approximate 1 year period, there was approximately 70 hours of therapy given by patient to respondent. When it became apparent to respondent that patient could not afford respondent's treatment fee of $95 an hour, respondent suggested to patient during August of 1981 that the patient, quote, work off, end quote, the cost of therapy by performing construction work at respondent's house located at 3744 Long Ridge Avenue. Then it details all the construction that Mr. Day apparently did at your house, correct?
That's an allegation.
Right.
Objection overruled.
Yeah, that's an allegation.
Well, and the allegation was that he designed, constructed, and installed a jacuzzi spa.
That's an allegation.
Was that true? Did he do that?
No.
He never did that. Did he do carpentry work on the eaves of your house?
I don't recall.
Did he remove trees in your yard?
I wasn't even there when he did virtually any of this, and I wouldn't know what he did specifically, except I certainly know that he didn't install a jacuzzi. He did perform, however, as I've stated, some work around the house, and I wasn't there when he did. And in fact, I went.
I believe to strike any that beyond personal knowledge.
Objection overruled. The answer will stand.
So
Did he install a sprinkler system?
I think I've just testified that I really wasn't even there when he did any of this work, and I don't know if he did or didn't install a sprinkler system.
Well, did you at some point during the period of time that this allegation relates to come home and see that there was a new sprinkler system at your house?
This was 10 or 12 years ago. I have no recollection of what work was done on a residence of mine that I'm not in 12 years ago at all. There was a large construction project ongoing with many different contractors and subcontractors, and Mr. Day was simply a handyman who was performing some tasks and not supervised by me and not at my direction.
All right, you said this is 10 years ago. You didn't mean to imply by that you had a lapse of memory as to what happened to you.
No, what I'm stating is that I didn't monitor Mr. Day, wasn't supervising Mr. Day's work, and I don't recall what day a sprinkler system was installed at a house when I wasn't even present 12 years ago. I wasn't even there.
Because when you gave your explanation yesterday, you seem to have good memory of your involvement with Mr. Day. Would that be a fair summary your recollection?
Oh, I think I have a very good memory of my recollection of my therapeutic relationship with Mr. Day, but not of things that happened at my house when I wasn't present 12 years ago in relationship to a large construction project.
Now, it says that the actions of respondent in serving as the therapist of the patient and also simultaneously serving as the customer of the patient in engaging the patient to perform the construction work that is listed in subparagraphs C and D on respondent's house were a violation of the dual relationship provision of Section 6A of the Code of Ethics of the American Psychological Association and amounts to gross negligence in the practice of his profession on the part of respondent. The reason for this is that respondent lost the objectivity that a therapist should possess toward his patient and allowed his personal feelings about the quality of the construction work being performed on his house by patient to interfere with the therapy that he, respondent, was attempting to perform with patient. That was the accusation, correct?
That was the allegation.
Right. And the board, at least the people responsible, the Attorney General's office brought this allegation, correct?
It's simply an allegation.
And at least the allegation wasn't characterized as a technical violation, was it?
Objection, pause for completion.
Overall,
The allegation wasn't, but the stipulation was.
All right.
The agreement that we agreed upon, including the state agreeing upon, was something very different than what's stated in the accusation and the allegation.
And basically what happened is your attorney went in and made a deal, isn't that correct?
No, that's not correct.
That's not correct.
That's not how I would characterize it.
But wasn't there a period where your lawyer, long period of time where your lawyer was trying to negotiate with the MFCC board not to file charges against you and representing to them that you were in negotiations with the psychology board?
Irrelevant, Your Honor.
sustained.
Now, turning to Exhibit 123. The stipulation itself, you agreed in writing to the following facts, which I'm going to read to you. During the period of time that began in June 81 and ended in June of 82, respondent treated patient CD in individual therapy. This therapy treatment continued on an irregular basis,
May continued on.
on an irregular basis, some weekly sessions, some multiple sessions on weekends. During the course of treatment, respondent and patient agreed that patient would work off the cost of therapy by performing construction work at respondent's house. Patient did perform construction work at respondent's house during the period between November 1981 and November 82. The actions by respondent in serving as the therapist of the patient and also simultaneously serving as the customer of the patient in engaging the patient to perform construction work on respondent's house were a violation of the dual relationship provision of Section 6A of the Code of Ethics of the American Psychological Association, in violation of the provisions of Section 2960 of the Business and Professions Code. Respondent agreed to the dual relationship because respondent believed the patient would not otherwise receive therapy.
I think
Is that what you agreed to?
yes, I think that's entirely consistent with my testimony.
And where in there does it say that it was a technical violation, Doctor?
There's an argument of it.
Rephrase the question, please.
Where in the documents in 123 and 124, if there is such a place, does it state that what you did was a technical violation?
It doesn't state that in the document.
And they placed you on a period of probation for 5 years for a technical violation, correct, according to those documents?
I was told that it was a technical violation by the supervisor who actually was in contact with the board and who actually believed that I shouldn't have been on probation at all and tried to.
Objection, Your Honor. Testify the youngest person or-
Objection overruled.
Well,
Uh,
was
the-
that included?
I
By the
wasn't-
way, it hasn't
I
finished.
wasn't finished.
Sure. Go ahead.
The supervisor, actually Dr. Lulo, the first meeting that I had with him,
Your Honor, I'm going to object to this calling for hearsay.
Objection overruled. It's not offered for the truth, but as to the state of mind of the witness as to why he characterized this as a technical violation.
stated that he had never heard of anyone being disciplined for a dual relationship of this kind ever in the history of California, And he said that it was very frequent that therapists had dual relationships with patients and that they were not ordinarily disciplined. He then called the board and said, is there something about this situation that I don't understand? What did Dr. Oziel do that I don't understand, that he's even on probation? This seems to serve no purpose. The board, according to Dr. Lulo, told him, there's nothing that you don't understand. It's simply that it got into the system, and the person who filed a complaint against Dr. Oziel happened to be on the ethical board and pressed hard for there to be an action taken because he's an ethics person. And Dr. Lulo then told those people that he did not, and he wrote letters, he wrote letters stating,
Excuse me.
Is there an objection, counsel?
Yes, Your Honor, now we're getting into multiple hearsay going in the
All
other
right,
direction.
none of this is offered for the truth of any of these things said by other people. It just reflects on why this witness has characterized this as a technical violation, and the jury is to be received for that purpose only.
Dr. Lulo told me that he, after talking with the board and talking with numerous people at the board, he concluded that it was inappropriate that that I had even been disciplined for this. When he asked them what I did, and he asked them whether there was anything that was more serious than what he understood, he repeated what he understood.
Repeating himself.
Okay,
Objection overruled.
that the board said, no, it isn't any more serious than you think it is. It's just what it looks like. It's just he got into the system, and once he got into the system, there was no way to get him out of the system. So that's why he's on probation. And Dr. Lulo said to me, this is nothing but a technical violation. And he said, it's obvious it was a mistake. And it's also obvious you shouldn't be on probation. And he then proceeded to write multiple letters to the board requesting that the board terminate my meetings with him, not a call for me to take the examination. And as a matter of fact, there are 4 reports that he wrote to the board requesting them to
Yes,
remove
Your Honor,
me.
this is no longer what Dr. Lulo is telling you.
All right, the objection at this point is sustained. The witness has answered the question. Your next question, please.
And Dr. Oziel, after all this urging by Dr. Lulo and yourself, did the board take down probation?
The board did not take me on probation.
Very much. And, sir, you didn't mean to imply by your testimony that that was a technical violation, that you weren't committing other illegal acts and unethical acts during the period of your probation, were you?
Objection argumentative.
Sustained.
One of the conditions of your probation was that during the period of your 5 years probation that you were to obey all laws, correct?
That's correct.
And you were supposed to be going to Dr. Lulu and reporting.
Lulo?
Lulu?
No.
His name isn't Lulu?
His name is Dr.
Lulo.
Lulo.
I see. You were supposed to be going to him as part of your probation and reporting to him any ethical problems that you might be having, correct?
That's correct, I believe.
And these letters that he was writing was basically, they were basically based on what you came out of the discussions you had with him about the nature of the problem, correct?
No, I would state that they came out of Dr. Lulo on a weekly basis, evaluating all aspects of how I conducted myself with patients and basically concluding that.
And that information that he had, which formed the basis of these letters, was in large part based on your meetings with him.
In some part.
All right. And what you weren't telling him was that you were continuing to violate the ethical codes of your profession during the period of your probation. Isn't that true?
Objection argumentative and supersection argumentative.
Sustained.
Were you telling him during the period of time you were under his supervision that you were committing other unethical acts?
No, I wasn't.
And in fact, you were, though, weren't you?
I have no idea what you're talking about.
Well, were you committing acts in violation of both your probation and in violation of the law during the period of your probation?
Not that I'm aware of, Mr. Burt.
Well, would it be a violation of the law and a violation of your code of ethics to prescribe and send drugs to patients through the mail?
Objection irrelevant, and I believe we've had a ruling on this already.
Objection under section 352 of the evidence code is sustained.
Right. And would it be a violation of your ethical code and a violation of the law for you to be attempting to extort money from a former patient by the use of tape recorded information?
I wouldn't know, but it sounds like it would, and that's nothing that ever occurred.
Right. And
All right, ladies and gentlemen, we'll take our morning recess and we'll resume at 15 minutes after the hour. Don't discuss this case with anyone. Don't form any final opinions about it. We'll see you all back here 15 minutes after the hour, and we'll have counsel back at 5 minutes after the hour. In the trial, the defendants are in court and counsel. The jury is not. You were going to mark, or you did mark, 2 letters or 2 documents as exhibits, Mr. Burt.
Yes.
And what is it that you propose to do with them?
Question the witness as to whether he wrote the documents. And as to exhibit 125, which is a letter dated October 25th, 1986, ask him whether the letter was an attempt by him to use a tape to extort money from the person that the letter was addressed to. Just those 2 questions. In other words, did you write this letter? Was this letter an attempt by you to use a tape in your possession to extort money from the person that the letter was directed to? With reference to 126, I'm simply going to ask him whether he wrote these letters as a foundation for a witness who will testify as to receiving them, and to hopefully will be able to testify to the contents of the letters as non-hearsay to show a pattern of obsessive character trait by Dr. Oziel in pursuing his girlfriends. And second of all, to show him violating the ethical and criminal laws in sending this person, who was a former patient, medication through the mails, specifically Prozac, which the last page of the December 12th letter.
What year?
December 12th, 1988, during the period of his probation, he states his several points in the letter, his diagnosis of this woman, and signs off the letter with, I sent you the Prozac. You're a big girl, but you should take it. Say hello to everybody. Miss you, Alex. And then signs off. So that is responsive to his testimony that during that period of time of his probationary period, he merely engaged in a technical violation, and that there was no other violation that was going on, and also responsive to his lengthy explanation indicating that he and Dr. Lula had decided, based on their consultations, that he had no need to be on probation.
Well, the technical violation was a description the witness gave in relationship to what caused him to be on probation, nothing to do with whether he committed technical violations while on probation. But regardless of that, what is the people's response?
Your Honor, the people's response is that these items should neither be marked nor authenticated, nor should the witness be questioned about them. It appears that we are again going into collateral impeachment. I believe the court originally indicated that Ms. Smith could be brought into the trial as issues are relevant to the Menendez brothers. But it seems to me now what we're trying to do is bolster either her anticipated testimony or impeach the credibility of this witness with very, very collateral matters, which not only are irrelevant to the issues in this case, but will also necessitate the litigation of the accusation, or at least part of the accusation filed recently by the Attorney General's office, and will require a great consumption of time in order for us to rebut, explain, and deal with this particular issue. And this is the basis also of our objection to the testimony of Ms. McPhee and Ms. Curry. And since,
So let's not get to that yet.
okay, fine.
All right. Did you want to respond?
No, Your Honor, I'm just asking the witness to authenticate the documents, and that's with respect to 125, I had the main question I indicated to the court.
All right. The objection made by the prosecution is under Section 352 of the Evidence Code, and the issue is whether or not this evidence has probative value and whether the probative value substantially outweighs the probability that its admission will necessitate the undue consumption of time, create a substantial danger of prejudice, or confuse the issues or mislead the jury. That's the issue before the court. Most of what Mr. Byrd has referred to relates to the defense impeachment of the witness in regards to whether he was on probation at the time he was treating the defendants. That's how this whole thing started. The court permitted the defense to question the witness as to whether he was on probation at the time of this conversation that is the issue in this witness's testimony. And we've gone far afield from that and distracted from that to the point of the defense now seeking to impeach the witness on matters that are completely collateral and irrelevant to the underlying issues in this case. And the defense has had more than ample opportunity to cross-examine the witness on these subjects. The court finds that the objection by the prosecution is well taken, that these matters are clearly irrelevant, not probative, and whatever little probative value they might have is substantially outweighed by the probability that its admission will necessitate undue consumption of time and create substantial danger of prejudice and confuse the issues and mislead the jury, and therefore the court will sustain the objections to the questioning of the witness as to these documents. They can be marked as exhibits and they'll be lodged as such, but they will not be subject to questioning of this witness.
And that would include asking him whether he wrote them down.
Yes.
And I just wanted two things here. One is perhaps I wasn't clear in stating to the court that the offer of proof also related to our affirmative defense, not simply on impeachment of Dr. Oziel on his probation, but also to establish that it was Dr. Oziel's habit and custom to manipulate former patients and insinuate himself into their private and financial affairs. And that, we allege, is the motivation for his making up false statements on the tape. So it's also part of that offer of proof, which we've attempted to pursue so far unsuccessfully through evidence which we've offered, tape recorded evidence proving that. But so far we've been unable to get any evidence before the jury because it's been successfully blocked on 352 objections. So I just wanted the record to be clear that we were also including that as part of our offer of proof. And second of all, that for the record, we would make a motion to strike Dr. Oziel's testimony on the constitutional grounds that we stated the other day in support of our motion to strike.
All right, those observations are noted, and the request to strike the witness's testimony is denied. As I've indicated, the defense has been given ample opportunity to cross-examine the witness and attack his credibility on various grounds. And at this point, the additional argument that you're making that this is an affirmative defense, number one, it's not technically an affirmative defense. It's something that you intend to offer to impeach the witness. That's not an affirmative defense, but that's evidence to attack the quality of the evidence being offered by the prosecution. And at this point, based upon what has been presented to me, it appears that that evidence is highly speculative and conjecture and again falls within Evidence Code Section 352 regarding it having little, if any, probative value and has a substantial danger of potential confusion of issues and misleading of the jury. So unless there is specific evidence relating to these defendants and what you allege occurred between Dr. Oziel and these defendants, at this point, based upon what little offer of proof you've made, the court sustains the objection of the prosecution in relationship to this secondary theory that you put forward here.
All right, Your Honor, could we conduct a 402 hearing so that I could make a proper record as to what Dr. Oziel would testify about concerning these documents so the court can adequately balance and evaluate what the nature of the testimony would be?
Not at this point. If this is evidence you intend to offer, it can be offered during the defense, and you can make your offer proof prior to that time as far as what you think and expect the evidence to be. But I don't think it's a proper area of cross-examination of this witness. It goes well beyond the scope of the examination of the witness into highly collateral matters, and wouldn't be a proper part of the cross-examination.
Could I be heard briefly on one other matter which has nothing to do
Well,
with
let me
this
be
issue?
heard on this. I would just like to say, Your Honor, is the court in fact coming up with a evidentiary rule for this case that the chief witness for the prosecution, whose credibility is the core issue in this case, cannot be collaterally impeached in spite of Wheeler, in spite of the evidence code?
No,
All forms of collateral impeachment are going to be considered too time-consuming for this witness?
well, counsel, perhaps you weren't here for the last 3.5 days of
Oh, I was
cross-examination of the witness, but he has been examined sufficiently and at great length on what many would regard as collateral matters. What this court is doing is saying that the court will follow the dictates of People versus Wheeler and exercise its discretion under Section 352 of the Evidence Code in dealing with what is and what is not proper evidence to be introduced in the trial.
Well, I have also been here and seen that this witness, who is extremely self-righteous and self-justifying, has been permitted on numerous occasions, though not on all, but more often than not, to make broad, lengthy statements in which he opens the door on these collateral issues, and then we have not been permitted to follow up on his volunteered information. It was not the defense in a question that solicited, for example, the ups, downs, pursuits and non-pursuits of his relationship with Ms. Smith. He offered that for the first time as one of the reasons why he told her. This court knows we had extensive hearings in 1990 concerning why he told Ms. Smith. The reason he offered in this court was never offered during those hearings. Court has the transcripts. He volunteered that. He plugged that in as the first reason he gave, and therefore our following up on that issue cannot be called collateral nor brought about by the defense. It is what he gave as his justification for telling her. With respect to other patients, he went in, he offered that the court day situation was a technical violation and that his probation in effect was meaningless. And therefore, we were forced to try to confront him with the true facts of that. Now, one of these witnesses,
Hasn't that been allowed?
well, except, he.
No, you're talking about things that have not been allowed, counsel.
My point is-
Wait, let me finish. I permitted you to go into this relationship with Judalon Smith beyond the initial ruling of the court
Right.
because of what occurred in the witness's testimony. So you were permitted to do that. I
Exactly.
permitted you to go into the area regarding the probationary status and why he was on probation. So those areas were permitted during the cross-examination of the witness.
But my point is when he denies it and when he does what we believe is lying about these relationships, particularly now lying about court day, Ms. McPhee lived in his house during the court day incident. We would offer her testimony to talk about the lies he just told.
We're not talking about McPhee. We can get to that, and I'll rule on that at the appropriate time. At this point, we're talking about what can and cannot be asked of this witness during the balance of the cross-examination. And unless you have something further to offer in that regard, we're going to resume with the juries.
Well, the fact that he wrote a letter in which he was threatening someone with criminal charges, civil charges, because he had surreptitiously made an incriminating tape, we think comes very close to the facts of this case. And that was the only question that Mr. Burt was offering at this point out of the letter of Ms. McPhee. That is precisely what we say is happening in this case. He made these tapes for extortionist purposes and threatened our clients with them. Now, I can't track it any closer than that, Judge.
All right, I've reviewed the report related to Ms. McPhee, and I'll be glad to deal with that when the issue arises and counsel need a ruling under Section 352 of the Evidence Code. But at this point, based upon what's been presented to me, this is entirely collateral, irrelevant to the issues in this case, and would unduly consume the time of this trial and prolong the trial and confuse issues. We're basically in the process of creating a straw man for the defendants to blow apart without any attention being given to the underlying facts of this case. And that's basically what's happening here. And that is the reason why the court has ruled that these areas are collateral. All right. Anything else before the jury comes in?
Yeah, Your Honor, it's on a collateral and maybe the court would think a trivial matter, but very early on in the case, I approached her bailiff, and I think other counsel did too, and asked the bailiff for permission to use the restrooms in the back corridor. And the purpose for that was because in using the restrooms outside, the public restrooms, it became apparent very early on that there were people from the media and also jurors, and that sometimes unknowingly things would be in a situation where someone would say something. So to avoid that situation, we asked for permission to use the restrooms in back. And I was just informed by your clerk that there was now an order that we couldn't do that and that we were required to go to another floor. And I'm wondering if that is a court's order, and if so, whether there was anything that happened today that led to that order.
No, let me back up and say I was not until today aware that you were doing that. So my reaction was to the fact that I was not aware of it before. What I will do is permit you to do that, use this restroom in the back, with the understanding that if there are recesses and you have a sufficient amount of time, that you can use a different floor as well, so that we not have this being the only resource that counsel utilize. All right. How much more examination do you have of this witness?
Based on the court's rulings, very little.
Okay,
I'd say
and
about 5 minutes.
Okay. After that, is there any further redirect or further examination by the prosecution?
Not as far as I know.
All right. That's then a situation where the defense or Eric Menendez wanted to question the witness.
Yes, I haven't crossed him on that part at all.
That's what I mean. And how long you think that'll be?
Depends on whether he answers the questions. If he answers the questions, I'm going to ask the sorts of questions he could say yes or no if he were so inclined, and could be done in an hour. But he's probably not so inclined.
All right. Well, we'll see if we're all so inclined to finish it within an hour.
I just want to get him off. I just want to ask specific questions and get him off.
What I will, let me back up here to go back to the scheduling. After that bit of evidence before the Eric Menendez jury, then there will be further evidence by the prosecution. And what is it that you intend to do?
Your Honor, the next witness that I would like to call would be Mr. Linhart, who is going to meet with Mr. Burt and myself at lunch. And so I would want to put him on. We may be able to resolve the pro-issue issues at lunch.
So that will involve both juries?
Yes.
Okay.
Your Honor, I should indicate also, Ms. McPhee and her attorney are here today. And we would like to at least have some sort of 402 ruling and to find out if they're going to be required here another day.
All right.
Is she in the courtroom presently?
Yes.
I would ask to have her excluded, please.
I don't even know who she is or where she is.
Well,
Your Honor, there's been no exclusion order in this trial. We haven't excluded prosecution witnesses.
Okay. Well, as I recall, this morning, Mr. Brunon was excluded at the request of one of the defense counsel. And his contact with this case would be much less than perhaps that witness who you're referring to now.
Well, I don't know. So far, all we've heard about that witness is that she's 352able collateral. So I don't know what.
Well, I don't know if she is going to be a witness, but it would seem that she is not family, so she should be excluded from this courtroom. The court has made an exception for the family members who can't stay. So if this Ms. McPhee is in the courtroom, she is excluded from the courtroom, and counsel will have to instruct her as to how to behave so that she has no contact with the jurors and doesn't speak with or anyone in the presence of the jurors. All right. If there is nothing else, we'll resume with the examination before both juries. We'll then excuse the one jury, allowing hopefully sufficient time to complete the examination before the Eric Menendez jury, and then we'll have the other jury back. All right, the jurors are all back. If the witness would get back on the witness stand, please, and the record will reflect that all counsel are here as well as both defendants. All right, Mr. Burt.
Dr. Oziel, were you asked to bring some additional letters to court with you from Ms. Smith?
I'm sorry?
Were you asked by the prosecution to bring some additional letters that you have from Ms. Smith?
No,
Do you have any letters with you from Ms. Smith?
I do not.
Whether you were asked to bring them or not?
No, I don't.
Now, getting back to this court day thing, you described that as a technical violation. I think you also said that court day sued you. Is that correct?
Judge, may I ask an answer?
Overall,
Yes,
And do you know how much money your insurance company ended up paying him?
Judge, irrelevant.
sustain.
Did you get involved in the settlement negotiations between the lawyer for the insurance, your insurance company, and court day in settling his lawsuit?
I don't recall.
He sued you for medical malpractice?
That would be inaccurate.
Inaccurate or accurate?
Inaccurate.
What did he sue you for?
He couldn't sue me for medical malpractice. I'm not a physician. He sued me for professional liability, but I don't recall what the actual complaint was. It was a long time ago.
But malpractice was the basic
Some,
psychological malpractice?
that's what he sued me for, yes.
Right. Was that, in your view, a technical lawsuit?
Judge, argumentative.
Sustain.
Was the lawsuit that was filed against you a technical lawsuit in your view?
Objection, sustain.
You also have currently pending against you an accusation filed by the Attorney General of the state of California.
Objection beyond scope.
Overall,
Yes, I stated that.
And in your view, is that also a technical violation?
I can't answer that question, Mr. Byrd. It doesn't relate to the question you asked before.
You have an explanation, I think you said, for that one too, right?
I'm not following any of the questions you're asking. Could you please restate what you're asking?
You're aware that the Attorney General has filed another complaint against you, correct?
Yes, the second complaint. That's correct.
And my question is, you have an explanation for that one too, correct?
Objection irrelevant. Beyond scope.
objection, sustain.
Doctor, you feel you have an explanation for everything that's been asked of you here in the courtroom, isn't that true?
Objection argumentative.
Sustain.
Doctor, do you have a book deal in the works right now?
No, I don't.
Have you talked about writing a book about your experience in this case?
Beyond scope.
Says on,
Sorry?
says on the issue of his reluctance as a witness.
Objection overruled. What was the question? Let's have it read back, please.
Question, have you talked about writing a book about your experiences in this case?
I wouldn't characterize that as being a true statement, no.
Well, in what ways isn't it true?
Well, at one point, going through all of the political and different kinds of situations that have come up, I think I might have mused that it might be interesting someday to write all that down and maybe write a book about my own personal experiences, not having to do with the Menendezes per se at all. And that was amusing, and there was never any agreement to do anything. It was simply something that I communicated.
That you communicated to who?
Probably to one or two people, just in musing over all these years.
And was a literary agent contacted pursuant to those musings?
Yes, actually, a person associated with the public relations firm that did the press conference gave me a call and suggested that she had had a conversation with someone who was a literary agent who would be interested in talking with me or might be interested in talking with me. That person, I had a conversation saying it was just something that I'd considered and that it wasn't appropriate at this time. Person arrived in town, called me, did not return the person's call, had a secretary return the person's call and say it would be completely inappropriate for me to discuss anything about anything like that now. And if ever there was such a thing to even be discussed, it wouldn't be until after the trial was totally over. And I didn't even know in any event whether that was anything that I'd ever want to do.
All right, so you focus on now is not the appropriate time.
No, I think what I stated is that I don't know if that's anything I'd ever want to do.
And have your musings included how much money you could potentially make for over writing such a book?
No, that was never even raised as an issue, discussed, and it wasn't even anything that I thought of.
Never entered your mind.
No, what entered my mind was an opportunity to discuss what it's like to be a witness in this kind of a situation, and how actually being a witness in many ways is like being put on trial, except that you don't have representation and you have no attorney who has standing to represent you. So it's this experience, actually, Mr. Burt, that we're having right now that I thought might be interesting for people to understand about the position of being a witness in a widely publicized murder trial. So that was my incentive, being able to express this experience and potentially, if I ever decided to do such a thing, to allow other people to be able to understand something about what it's like.
And that would be strictly out of educational, humanitarian goals on your part in terms of educating the public, would it not?
Objection, argumentative.
Overruled.
Now, if I ever did have that musing or that feeling, the primary purpose would have been my desire to, at some level, express what my experiences have been. Definitely was not for financial purposes.
And by the way, you've been represented throughout these proceedings in this court, have you not?
Well, I have an attorney, but he doesn't have standing with respect to this.
Well, he's appeared many times in this court and made arguments on your behalf, has he not?
Objection irrelevant, Your Honor.
Overruled.
He's appeared several times, yes.
Made arguments on your behalf? in
Yes,
this
he
court?
has.
So it's not like you were in here all by yourself, having to fend for yourself, was it?
Well, I think Mr. Brunon has been here a very small, almost negligible percentage of the time that I've been here.
He's been here to represent you when you wanted him to, has he not?
Sometimes.
And has your musings about this book possibility included musings that any money that was offered to you would be refused?
I think I answered the question that I never thought about the money one way or the other, and that never entered into any discussion.
Well, my question is, if you did write such a book, would you take money for it? Or would you refuse it on ethical grounds?
Objection calls for speculation.
Overruled.
No, I don't think that I would refuse money, but I never decided to write the book to begin with. And secondly, that wasn't the basis for me ever even considering it. And it was amusing. It was not a plan. And I have no preparation plan, outline, or discussion or agreement with anyone to write a book.
Now, correct?
I never have had one, don't have one. And in my own mind right now, I have no intention of writing a book.
In your own mind, correct?
That's correct, Mr. Burt.
That's all I have.
All right. At this point, ladies and gentlemen, what we will do is have examination of the witness, which will relate only to the Eric Menendez jury, and therefore the Lyle Menendez jury will be excused. What I'll do is have you on the Lyle Menendez jury come back at 3 o'clock, give you a long lunch hour, and hopefully by then we'll have completed this other examination. And it's possible it'll still be going on. I don't know for sure, but hopefully we'll be in a position to have you back in the courtroom around that time. So report back to your jury room and don't discuss this case with anyone. Don't form any final opinions about it. And we'll see you all back around 3 o'clock in the jury room next door. All right, this will be the examination of the witness before the Eric Menendez jury only. And at 1:30, we'll have you in the jury box. We'll keep you where you are at this point, ladies and gentlemen, so that the examination can be commenced at this point.
Your Honor, just for guidance, I believe I'm entitled to do now cross and recross. Is that
Yes.
correct? Thank you.
I'm sorry. Go.
Which branch of the Army? Army 1, Army 3, which Army were you in?
I don't have any idea what Army 1 and Army 3 mean.
Did you ever hear of the Big Red 1, for example?
No, I never did.
The Army, the United States Army, is broken up into different actual armies, and people are assigned to those sub-armies. Did you know that?
No.
Where did you serve in the United States Army?
I was in Fort Knox, and then I was at Fort Lewis.
And you said you were honorably discharged in June of 1968. Is that right?
I believe that's true.
And isn't that also the time that you got your psychology Bachelor of Science? Same time, June 1968, for the University of Washington.
That's correct.
You were in the ROTC, weren't you?
I was in the Army and honorably discharged. If you like, I can bring in the honorable discharge.
Were you in the ROTC?
Yes, I was in the ROTC.
That was the full extent of your Army experience, was the Reserve Officer Training Corps, isn't that correct?
The Reserve Officer Training Corps, the advanced individual training for officers. And at the point that I was about to assume duties as a lieutenant in the Army, they discharged me for medical purposes that had to do with medical condition that I had at the time.
So unlike everybody else, or unlike most people who were in the ROTC in college, who after college then go and serve active duty, you never did. Isn't that true?
No, I never claimed to serve active duty.
And what was the nature of the medical disability that discharged you before you served active duty?
I had some severe food allergies that the Army felt would result in serious problems for me if I stayed in the Army.
And this was in 1968 while the Vietnam War was going on, is that right?
That's correct.
Now, I want to read to you the letter dated June 15th, 1989, that you said was sent to you by Judalon Smith following upon numerous lengthy discussions about business proposals. Okay, you know which letter I mean?
No.
May I approach?
Well, let me see counsel at the sidebar here before you do that. All right?
May I approach, Your Honor?
Yes.
Showing you Exhibit 120. That's the June 15th letter that I'm referring to.
Okay.
All right, now I'd like to read this to you. Hi, Jerry. Thank you for your time and consideration. Enclosed is my poetry book as a token. Now, do you know what she is referring to, what Ms. Smith is referring to about your time?
I just think that she's referring to having had the patience to listen to her present her pitch or her proposal to me, her business proposal.
And her business proposal was that she would produce a line of tapes for you? Is that what you're saying?
That and duplicate tapes, both.
All right. And explain to me why the next paragraph begins, if you don't have your own tape line, you should. And since that is my business, perhaps I could be of some help to you or the center. So please file my business card for future use. Isn't that what it says?
All right, counsel, if you would let the witness read it to himself, and then you can re-ask the question. The objection is sustained to the form of the question.
Why don't you read that to yourself?
I've read it.
Now, doesn't it appear from the phraseology here that she is inquiring as to whether you have your own tape line?
I don't know, I'd be speculating, but I think she was probably just, if you want me to speculate?
No, I want you, if you don't know the answer or the answer is no, say no.
I don't know.
Fine. And when she says, perhaps I could be of some help to you, does that sound like you've already had a conversation where you've discussed in detail business proposals with her?
Just also speculation.
Sustained.
Isn't it true that this is the first time after all of your lengthy phone conversations that Ms. Smith ever raised her business side to you?
No, it's absolutely false.
And she sends you with this letter, does she not?
Counsel, unless there's a need to be up there at the
Well, I wanted to punch the
bench,
exhibit.
at the witness stand, why don't you go back to the
Well,
podium?
may I ask a question for clarification?
Well,
of
he
the
could
witness
he could
first?
see that there, so you could go back.
That's a Xerox copy, is it not, Dr. Oziel?
It is?
And part of what's on that Xerox is a Xerox of the business card, which is at the top of the letter, correct?
That's correct.
And so she does send you her business card with that letter, is that correct?
That is a business card she sent with that letter.
And are you saying that she had sent you numerous business cards before that?
I don't recall. I certainly had a lot of different business cards sent to me by Judalon Smith, and I wouldn't recall when she sent me which one.
It appears, however, that from the tone of that letter, that this is the first time she's sending you a business card, doesn't it?
Speculation.
Sustained.
Well, is that how you interpret that letter?
I don't interpret anything. It would be speculating.
And how long after you received her business card and that letter did you meet her?
I don't recall.
Well, you estimate you were talking to her on the phone for several weeks before that. How many weeks after did you meet her?
All right, counsel, again, that's an argumentative question.
You have no recollection how long after that you met her?
Okay, again, the question has no meaning since it's out of context, so you have to rephrase the question.
Thank you, Your Honor. Do you recall how long after the June 15th letter you met Miss Smith?
No, I don't. With any
No
precision.
idea at all?
No, I said with any precision. I could estimate. Are you
Please
asking me?
estimate.
I would estimate it was within several weeks of this letter, but I don't recall.
Okay, so the first time you met her was several weeks after your receipt of that letter.
No, I said that would be my best estimate.
Your
of when
best
I met
estimate
her.
is the first time you laid eyes upon her was within several weeks of receipt of that letter. Is that correct?
To the best of my recollection.
And prior to meeting her, did you send her blank stationery from the Beverly Psychiatric and Psychological Center?
No, I didn't.
Then can you explain, Dr. Oziel, how it is that Judalon Smith signed a confidentiality agreement dated June 1st, 1989 on your letterhead?
Yes, I can. Would you like me to explain it?
Let me just make sure we're talking about the same thing. Exhibit 101.
I know what we're talking about. Want me to explain it?
No. Want to ask a question.
Okay.
Isn't it true, in fact, that you asked Judalon Smith to write a confidentiality agreement, that one, sometime after November 2nd, 1989, and you told her to backdate it to make it appear that she had a confidentiality agreement with you before the meeting of October 31st?
No, it is not.
Ron, I want to go into one other area of my, no, it's an area of my cross. Never mind. It's an area of my cross. You were shown shotgun purchase records, your shotgun purchase records,
That's correct.
and you signed on one of those records?
That's to my recollection. I did.
Your wife signed on the other?
That's correct.
Did you discuss with your wife before you purchased the shotguns how you would use them?
No.
Did you discuss with your wife after you purchased the shotguns how you would use them?
No.
Overruled.
Did you discuss with Ms. Smith how she should use the shotgun that you put into her hands on November 6th?
Can you clarify what you mean by how you should use them?
You didn't understand the question.
No, actually, I'm just thinking as you're asking it that you may be meaning something that I don't understand.
Well, let me ask you this. When you decided to purchase these shotguns, how did you envision that you would use it?
I envisioned that I would use the shotgun to protect myself in the event someone was coming to harm me physically.
Just anyone or someone in particular?
Well, specifically, the concern I had at that time was that Lyle or Eric would, or both of them, would be potentially a danger to my life. And that is the reason that I purchased the shotguns. I think I've testified to that.
Now, you didn't carry these shotguns around with you in your car, did you?
No, I didn't.
You didn't take them to your office, did you?
No, I didn't.
You left them at your home for use there, correct?
That's correct.
So isn't it true that you envisioned some scenario where Eric and Lyle would come to your house and you would use that shotgun?
No, that wouldn't be a correct conclusion.
You never thought of that?
No, I did think of that.
Okay, tell me what you thought. What did you picture? Them coming and somehow breaking into your house, correct?
That was one potential, yes.
Okay, and you envisioned that possibility happening, correct?
Among a great many other possibilities, yes.
And you envisioned yourself taking that shotgun and using it to defend yourself against Eric and Lyle at your home, correct?
If they were coming to kill me, yes.
Okay. And you envisioned yourself, therefore, killing your patients potentially if necessary, correct?
If they were about to kill me.
And you decided in working out this chain of events in your mind that that was preferable to calling the police. Is that correct?
No, that's not correct.
Now, I'd like to give you Exhibit 97. May I approach you?
Yes.
I just want you to keep these in front of you for right now, Dr. Oziel. I'm going to get my copy. Now, Dr. Oziel, I want to talk to you about record keeping, okay? I'm going to ask you a series of very specific questions about record keeping. You understand?
I understand.
All right. Now, if you would take a look at the ledger cards. And I'd like to focus your attention.
All right, before you do that, we'll take our recess and we'll resume at 1:30, ladies and gentlemen. Don't discuss this case with anyone. Don't form any final opinions about it, and we'll resume at 1:30. I'll ask that counsel remain, however. All right, the jurors have gone, and my inquiry of the defense is, why is this examination occurring now? You had done cross-examination of the witness before both juries, and the people have done redirect. None of this, as I recall, regarding the ledgers was touched upon by the prosecution in its redirect examination.
No, this is part of my class that my co-counsel did not want gone into in front of your jury.
And you'll have to lay out for me exactly what it is, because you did go into extensively this area yourself, and
Let me explain what I'm going to ask.
the court did not give you the opportunity to do separate cross-examination, so that anything you forgot to ask earlier would be saved up for further examination at this point. This is to be truly examination that relates only to the Eric Menendez jury.
Okay, Judge. No, I don't care. I want him here, in fact.
Counsel, just speak to me, not to co-counsel.
Okay. What I'm going to be asking the witnesses in what I had previously, we've talked to at sidebar and has not been done yet. I'm going to call his attention to all of the therapy sessions that he testified in front of both juries that there were certain sessions that he had after November 2nd. Okay. I am going to focus his attention to the sessions that between the ledger book and the appointment book, it appears that he had with my client commencing, I'm still not able to read this. Just a second here. Why don't I get the original? All right, here we go. Commencing on this separate sheet, 1989, commencing December 12th. And what I'm going to do is focus him on those dates when, based on the appointment book and the ledger, there actually was a session, not cancellations, not no-shows, starting with December 12th. And I'm going to ask him very simply if he prepared notes. And just take him through those few sessions. I think there are 6. December 12th, December 19th, December 22nd, January 2nd, January 10th, January 23rd, January 30th, February 6th, February 13th, February 20th. Those, to ask him if he ever prepared any notes of those sessions.
That's all you're going to ask is that question, whether he prepared
Right.
notes of those sessions.
Exactly. And then I'm going to ask, based also on a previous ruling at sidebar, whether he had taken notes of the meetings he had had with my client and with my client's parents during the period of 1988, 1989 before the killings, and whether he destroyed those written notes, and whether he made those notes into tape recordings, and when he did that. And I don't mind the witness hearing this, because that's what I meant when I said I'm going to talk about record keeping.
You're saying all of this was objected to by code counsel for Lyle Menendez?
Yes, they didn't want to get, for whatever their protective purposes, they didn't want to get into this.
Is that correct?
Yes.
All right, then, do people wish to be heard?
Well, yes, after she asked if we kept notes of the sessions, I think starting with December the 12th, all through those, I take it we'll be able to ask him why he did or did not keep notes.
No, I think I would object to that because everything after that is privileged. I just want to know if there are notes and records.
Well, if he did keep notes, he'll answer yes. If he didn't keep notes, he'll answer no, he didn't.
Right.
And why don't you feel that people have a right to ask why he did or did not keep notes?
Well, I don't know.
If you think
what
it's
he's-
relevant that he did or didn't keep notes, why don't you think it's relevant as to why he did or didn't keep notes?
Because I don't know what he's going to say, and I don't know if he's going to reveal privileged things or if he's going to come up with new stories and theories about threats. If the people are going to insist on that, then let's have it in camera and see what he's going to say. I just want to know if I have all the records. That's all I care about.
Well, you can confer with him about that. My concern, you have all the records as far as I could see. You have the documents. The witness doesn't have them. These were all documents seized by the police. So other than
Well,
going
that's
through a series of dates, which has already been done by Mr. Burt, where Mr. Burt went through all of the same dates that you referred to, and the only difference is that perhaps Mr. Burt didn't ask if notes were kept. This has all been discussed. If you ask questions regarding why you did not keep notes, assuming he didn't keep, or if you ask questions if he did not keep notes, the obvious next question is as to why he didn't keep notes, and that would certainly open the door for that questioning, and I don't think it's necessary to conduct hearings outside the presence of the jury as to why or what he would say.
I'd like discovery then. This is the prosecution's witness. They apparently know what the answer is, and I don't. Before I cross-examine, the whole notion of this adversarial system is I don't want him to free-floating traps. I should know what that answer is, and I have no idea what it is.
Well, I don't know if the prosecution knows either, and Mr. Kriyama is shaking his head.
There are sessions that were still privileged, and she wants to get into still privileged sessions, so we don't know anything about what happened in the session.
I don't want to get into them. I just want to know if there's notes. I don't have any notes of these sessions, so I don't know what they were about.
Well, then what is the value or the import of asking the witness if there were notes? What is it that you want to accomplish?
Out of his presence, I will make an offer of proof.
Well, just make your offer of proof right now as to what it is that you wanted to accomplish. It seems to me that if you ask the questions regarding whether he took notes, the obvious response is, why did you or did you not take notes? And it's an appropriate inquiry, and there is no obligation for the witness to testify in advance to what an answer would be. So if you want to make your offer of proof, you can do that now.
No, I don't want to do it in front of the jury, in front of the witness, Your Honor. I think I'm too constrained. He'll simply come up with an answer to avoid if he does that.
Well, that's your argument. But at this
Yes, it
point,
is.
the court will indicate that if you do ask the questions, the prosecution would be permitted to ask their questions in response. All right, we'll be in recess until 1:30.
Well, let me just get one thing.
Yes.
They can ask him why. We still can't evade the privilege to answer. And we understand that, do we not? That just talking about whether there are notes or not does not open up the session.
Well, if you think it's so important to find out whether he did or did not keep notes, then his answer as to why he didn't keep notes, assuming he didn't, is relevant. And if it goes into privilege, then you are inviting that. That's what you're asking.
I'm asserting privilege, and we've said before, Your Honor, that relevance and privilege are two different concepts.
You said that, but you can also not use the privilege as a shield to alter the nature of what otherwise would be the response of the witness. You can't do that.
Then I needed 1024 hearing to see if in answering that question, the witness would have to reveal privilege material. That's exactly my point.
At this point, I'm not going to permit that hearing. All right, we'll be in recess till 1:30. Defendant Eric Menendez is in court with his lawyers. People are represented, and the jury for Eric Menendez is in court as well. Before we get started, let me just do what I've been doing in the past with you folks and ask whether or not any of you have been exposed to anything about this case in any form whatsoever outside of the courtroom since the trial began, other than what you've already told me individually. Anybody? If you have, would you raise your hand? If you have, no. Raise your hand if you have. Okay, nobody has. Okay. All right. Thank you very much. All right, we'll now resume with the testimony and with the witness, Dr. Oziel, if you get back on the stand, please. All right, you may continue your cross-examination.
Yeah, I better get Exhibit 97.
Yes, they're there.
Okay. Dr. Oziel, you have Exhibit 97, which is your ledger cards in front of you.
Yes, I do.
And you recall that Mr. Burt took you through those ledgers and had you identify all the dates upon which you had sessions with Eric and all the dates upon which you had consultations with his parents. You recall that?
Yes, I do.
Now, starting with September 30th, 1988, through all the meetings with the parents and sessions with Eric up until August 20th, did you prepare any kind of written notes of those meetings and sessions?
Yes, I did.
And did you prepare those notes generally during the meetings with the parents or the sessions with Eric?
No.
Did you prepare those notes, as was your general practice, sometime after the meetings and sessions?
That's correct.
And did you maintain those written, these are written notes on the notebook paper that you previously described you tended to use for notes?
Well, I think my testimony was that I used a variety of different kinds of paper for notes, but yes, it was on paper.
Okay. And you had these notes in some kind of patient file?
That's correct.
And how thick a pile of notes would you say you had between September 30th, strike that. How thick a pile of notes would you say you had comprising the notes beginning September 30th, 88 up to August 20th, 89? Can you show us with your fingers?
No, I couldn't do that.
Well, can you tell us with your words?
No, I couldn't do that either.
Well, was it a stack 3 feet high?
No, it definitely wasn't 3 feet high.
Well, give us your best estimate.
I don't think that I can relate to how thick the notes were. All I can tell you is that I had notes of sessions.
How many pages?
I don't recall.
Over 300?
No, not over 300.
Over 100?
I don't believe so.
Over 20?
I don't know.
Possible that it was even less than 20 pages of notes?
It's possible it was less. It's equally possible that it was more. I'm just guessing. I don't know.
Well, you never saw those notes. You wrote those notes as the sessions were progressing over 88 and 89, correct?
Yes.
And didn't you go back to that entire set of notes after November 2nd
Yes, I dictated some summaries of some of the things I thought were key from the notes
When did you do that?
sometime after November 2nd.
So sometime after November 2nd, you dictated a summary of some of the things that were in those written notes. That's what you just said, correct?
Some of the sessions.
I'm confused. Did you dictate a summary of what was in the written notes, or did you dictate a summary of some of the sessions that were represented by the written notes?
To the best of my recollection, I dictated some of the sessions and the bulk of what was in the sessions that I was dictating. I didn't include all the sessions, and I don't recall whether I dictated the entirety of the notes.
So you may not have dictated up information about each session that you actually had, is that correct?
That's correct.
And you might not have dictated everything for each session that you did dictate that was in the notes. Is that correct?
Could you repeat the second question?
Yes. Let's assume there was a session that you did do some dictating about, okay?
Yes.
When you say you dictated a summary from the notes, does that mean you might have left things out of the dictation that appeared in the written notes?
It's not my recollection that I left anything out of the sessions that I included, but it is my recollection that I didn't include all the sessions, and I don't have any more recollection than that.
You didn't include all the sessions that you had notes for? Is that what you're saying?
No, some of the sessions didn't seem particularly remarkable, and I was doing this I was basically just trying to capture with my dictation some of the things that had happened previously and to not have any written notes lying around.
I want to make sure I understand, Dr. Oziel. Are you saying that you dictated notes of the 88, 89 sessions off the top of your head or from the written notes?
No, I'm saying that I dictated the sessions from my memory of the written notes. I didn't have the notes in front of me at the time that I dictated the notes.
Oh, well, where were they?
I had destroyed the notes so as not to have any of this information around so that I could dictate them onto tape recordings and then store the tape recordings for the future.
You destroyed the notes before you dictated them?
That's what I just testified to, yes.
And you destroyed the notes after November 2nd?
No, I don't recall. Well, I guess I probably did. Or
So-
I don't know if it was October 31st or November 2nd. I don't know.
So first you destroy them and then you dictate what you remember from having read them. Is that what you're saying?
Basically, yes, that's what I'm stating.
When did you destroy the notes?
As I just said, sometime around the time that I heard the confession.
Well, sometime after the time that you
Well,
heard the confession, I gather.
I mean, near the time that I heard the confession.
Well, did you destroy these notes at the same time you were dictating the notes that you now have for October 31st and November 2nd?
No, I didn't. I destroyed the notes closer to the night of the confession.
And when did you do your dictating of those earlier notes, that year-long therapy history? When did you dictate the tape?
Soon after I destroyed the notes. Like
Before you dictated the October 31st, November 2nd tape or after?
No, before.
So you destroy the early notes and then you dictate up a set of substitute notes for the early sessions before you try to get down the 7.5 hours worth of sessions that you had with the Menendez brothers on October 31st and November 2nd. Is that what you're saying?
To the best of my recollection.
Didn't you have a safe in your house?
Yes, I did.
And you thought that it wasn't safe to put those written notes of the previous year's therapy in your safe at the house? Is that what you're saying?
My first response was to not have any written material anywhere in the house that related to anything that I thought could implicate Lyle or Eric Menendez in the commission of the murders of their parents. And so I thought that I think it's going to get into a privileged area.
No, why don't we get into this? You didn't even go to your house October 31st. Isn't that true?
No, I did not.
And you didn't go there November 1st.
I don't recall.
And you didn't go there November 2nd.
I think I said I don't recall.
Did you go there November 3rd?
Actually, it's not true that I didn't go there November 2nd.
Did you go there November 2nd?
Yes, I did.
When you were in terror and afraid?
Absolutely.
When did you go there November 2nd?
I went there after the session. Or I might have gone there November 1st, actually, or November 2nd. Sure, I did.
Didn't you say you were secreting yourself at the home of Judalon Smith after October 31st? That's why you sent your wife and kids away, right?
Counsel, that's an argumentative question. Re-ask the question.
Haven't you previously testified here that you were secreting yourself at the home of Judalon Smith?
I was.
But you went back to your own house.
I think I've testified to that several times now.
When did you testify to it the first time before just now?
Ask another question.
Why did you go back to your home November 1st?
For exactly these purposes.
To destroy things, is that correct?
To make sure that there was no evidence that might be related
I'm
to
going to
this.
object to that answer, Your Honor. This witness has been trying to do this.
Counsel,
for 3
if you
days.
want to argue the matter, you can do so outside the hearing of the jury, or you can do so at the end of the trial when counsel have an opportunity to argue the matter to the jury.
I'd like
you know
to go
that.
to the sidebar.
Objection is overruled.
Dr. Oziel, can you answer the question I asked you? Do you think you're able to do that?
Counsel, again, ask the question. Don't ask the witness about the nature of your questioning.
When you went back to your house on November 1st, did you destroy the documents that would have linked people to Judalon Smith?
No.
You left those there, is that correct? Yes?
To the
or
best of
no?
my recollection, I did.
Okay. So you could have gone back to your house on October 31st and destroyed all these papers that you say indicated there was a connection between you and Judalon Smith, couldn't you?
I didn't feel it was safe to go back to my house October 31st.
But it was safe to go back to your house November 1st. Is that what you're saying?
I'm saying I went back to my house
Is that what you're saying? Was it
Objection,
safe to go back November 1st?
Objection is sustained. The question is argumentative in form.
Did
We
you
asked the
feel,
question.
thank you, Your Honor, did you feel it was safe to go to your house on November 1st? Yes or no?
No, I didn't.
But you went there anyway, is that
That's
correct?
correct.
Did you feel it was safe to go back to your house on November 2nd? Yes or no?
Not to stay there.
Did
No.
you go back to your house on November 2nd?
I might have.
You don't remember.
I think I did.
You do remember.
I think I did.
Did you go by yourself or did you have Miss Smith with you?
I don't recall.
Did you sleep at your house the night of November 2nd?
No, I did not.
Did you sleep at your house the night of November 1st?
No, I did not.
Did you have an argument with Miss Smith at her house on November 2nd and leave?
I do not recall any argument with Miss Smith on any particular night, and I don't recall having left.
You don't recall leaving her house November 2nd and going back to your own house to spend the night?
No, I do not.
Did you spend the night anytime during the week of October 31st on? Did you spend a night with your wife at the Sportsman's Lodge?
Objection, this is beyond the scope.
Overruled.
No, I did not.
Did you return to your house on November 4th before you left for Newport Beach?
I don't recall.
Did you go to your house on November 4th in order to pick up a bathing suit to take with you to Newport Beach?
I don't recall.
While you were at your house on November 4th, did you show Miss Smith around the house?
Again, I don't recall.
Do you recall the first time you ever took Miss Smith to your home?
No, I don't.
Was there a first time that you ever took Miss Smith to your home?
Yes, there was.
Did you have a wine collection at that house?
I had some bottles of wine. I don't have a wine collection.
You had some bottles of wine, is that correct?
Sure, I own some bottles of wine.
Did you have bottles of wine at your house on November 4th, 1989?
Objection, irrelevant.
Sustained.
Did you show Miss Smith wine bottles at your house on November 4th, 1989?
Objection, beyond the scope.
Sustained.
Did you invite Miss Smith to loiter at your house on November 4th, 1989 for 2 hours?
Objection, vague, ambiguous, and irrelevant.
Sustained.
Now, it's your testimony that you were so afraid of Eric and Lyle that you had to leave town to go to Newport Beach. Is that correct?
That's my testimony.
And it's your testimony that you were so frightened by the fact that they didn't go to where you thought they were going in Hawaii that you bought shotguns. 3 of them on Monday, November 6th. Is that your
All
testimony?
right, this has been asked and answered. Go on to something else, please.
You talked to Dr. Lulo on October 31st, right?
That's correct.
And did Dr. Lulo tell you that you should write very detailed notes and place them in a safe place as soon as possible?
That's correct.
And did you tell Dr. Lulo that you were going to go back to your house and destroy notes? Did you
No.
tell him that?
No, I didn't.
You saw Eric for the first time on October 4th, 1988, correct?
He needs to be on the scope, Your Honor.
What is it? This is my cross.
I'm sorry?
This is my cross in front of the
All right,
jury.
the objection is overruled.
Thank you, Your Honor.
I believe I testified that I don't know whether I saw him on September 30th or not.
I didn't ask you about September 30th. I asked you about October 4th. Did you see him on October 4th?
No, counsel. You asked me whether I saw him for the first time on September 30th, and the answer is I don't know if that's on October 4th, and I don't know that that's true because I may have seen him September 30th.
There's nothing on your ledger that shows that you saw Eric on September 30th, is there?
There's nothing on my ledger at all reflecting who I saw or didn't see.
How about your appointment book? Do we have your 88 appointment book, or did you destroy that also?
Objection argument.
Overruled.
No, I think you have my appointment book.
I don't have any.
Counsel, let's not respond to the inquiry of the
Okay, what, the
witness.
appointment books that were
Counsel's
seized.
remark is stricken. Your next question, please.
Thank you. Do you recall that the appointment books that were seized from you on March 8th were your 1989 and your 1990 appointment books? Do you recall that?
I don't recall. They took everything that was in my possession that I'm aware of that had the name of Eric or Lyle or Mr. and Mrs. Menendez in the books.
Do you have your 1988 appointment books at this time?
I am not aware of whether I do or don't.
Is the
Again,
answer you don't know?
I don't know.
Okay. Have you looked for them at all since you started to be a witness here?
I have not.
And you don't have any recollection, I take it, of your destroyed notes to know if the session on September 30th was with Eric or Lyle or the parents or whoever. Is that correct?
That's correct. I don't recall whether, I know the parents were there. I remember that. I don't recall whether Eric was there or not.
All right. But you do have written down on your ledger that Eric was there October 4th, correct?
That's correct.
And so that is the first time that you could say with any degree of confidence that you saw him, correct?
That's the first time that I know certainly that I saw him.
Isn't that what I just asked you?
I don't know.
You don't know what I just asked?
Okay, counsel, he's given you the answer. Your next question, please.
In January of 1989, did Eric sign a waiver of confidentiality allowing you to tell his parents the content of his therapy with you?
Yes, he did.
And did you, subsequent to receiving that waiver, have conversations with his parents in which you availed yourself of that waiver of confidentiality?
At Eric's request,
Well,
I did
can you
discuss.
answer that yes or no? Did you do
No.
that?
Not based upon the form of the question you asked, counsel.
Did you have conversations with his parents after he signed a waiver in which you utilized that waiver to tell them things previously privileged?
Counsel, let's rephrase the question. Break it down.
Did you have meetings with the parents after Eric signed the waiver?
Yes, I did.
Did you, in the meetings with the parents, tell them things that you would not have been able to tell them but for the waiver?
That's correct.
What's the next? Your Honor, I have a document I'd like to mark, 127.
And what is that document?
It is it's on the letterhead of Beverly Psychiatric and Psychological Center, Release of Confidential Information, it's called.
May I approach your room?
Yes.
Showing you Exhibit 127, does that appear to be a copy of the release of confidential information that Eric signed?
No, it does not.
Does not?
Nope, it's not.
Didn't you provide that document to the Santa Monica court in 1990?
Yes, that's not the release that was signed by Eric Menendez vis-a-vis me discussing things with Eric Menendez. You just given me,
Eric Menendez?
I mean,
Jose and Kitty Menendez. Does it say their names?
this is the wrong release. You've given me the 118 to 218 release.
Uh-huh.
That, it's not the release, is it? It's Jerry Chala.
Also Jerry Chan.
Okay, well, I know there were multiple releases. Then it's my
Multiple
apology. Then it wasn't this. I know that I had Eric sign several releases, and I don't know whether this corresponds to the time period or not that you're discussing.
I
So,
asked you if in January he signed a release, and that's at least one of the releases that he signed so that you could discuss his therapy with his parents, correct?
that is one of the releases that Eric signed so that I could discuss his therapy.
With his parents and
And-
with his lawyer.
And with Jerry Chaliff, yes.
That was his lawyer, correct?
That's correct.
That was his lawyer on this burglary stuff, right? As
That's
you
correct.
understood. Now, did you also prepare a report, a psychological evaluation of Eric to be submitted to the juvenile court on his behalf?
Yes, I did.
May I mark this 128 wrong?
128. I
Can we
think that's the
approach this
report,
side?
is that the
It's called
report?
Confidential Psychological Evaluation, January 16th, 1989. Can we approach on this before I show it to the witness room?
All right.
Thank you.
All right, your next question, please.
The report that you prepared for juvenile court, did you address it to Jerry Chaliff, Eric's lawyer?
I don't recall. You'd have to show me the report.
But I mean, you don't recall who you addressed it to.
No.
Did you address it to Eric?
I don't recall who I addressed it to.
So you have no recollection of that?
No, I do not.
You recall you testified that when you dictated the notes of October 31st and November 2nd, you were sitting on your bed in your bedroom. Is that right?
That's correct.
And were you in the same place and in the same position when you dictated your memories of the other notes?
I may have been. I don't recall.
Do you have any actual memory of the process of dictating your memories of the previously written notes?
Yes, I do have a memory of dictating them, but I don't recall specifically if I was sitting on my bed or sitting on a chair in my bedroom or which place
But
I was
you were at
sitting
home.
in. Yes, I was at home.
By the way, you have mentioned the fact that, to your understanding, this family was referred to you by a therapist named Lester Summerfield. Is that correct?
That's correct.
And did you ever consult with Dr. Summerfield concerning what he knew? I'm not asking you to reveal those things. I'm just asking the fact, did you consult with him concerning what he knew about this family at any time when this family was, or any members of this family were in therapy with you?
No, I did not. And the family was not in treatment.
I said, or any members. Did you hear that part of my question?
Well, you also said the family, and I wanted
Did you
to
hear
clarify.
that
Okay,
part?
counsel, let's not bicker. Let's go on to another question, please.
To your knowledge, was Mrs. Menendez in treatment with Dr. Summerfield while you were seeing Lyle and Eric?
I don't know.
To your knowledge, was Mr. Menendez in treatment with anyone while you were seeing Lyle and Eric?
Objection, irrelevant.
Sustained.
Well, did you consult with any other therapists concerning this family during the time that Eric and Lyle were in treatment with you?
Objection, irrelevant.
Sustained.
Well, Your Honor, it's foundational.
We'll get on to the next issue then.
But it's not foundational to the next issue. It's foundational to other issues.
Well, get on to it.
After Eric and Lyle
talked to you on October 31st and November 2nd, apart from your consultation with therapists about your fears and threats and the limits of confidentiality, did you consult with any other mental health professionals concerning them, their treatment, anything like that?
No, I did not.
On November 2nd, 1989, did you and Ms. Smith go to Beverly Hills together prior to the session with Eric and Lyle?
I don't have any recollection of that.
Do you have any recollection of Ms. Smith going down to a clothing store known as The Limited to make some purchases that afternoon before the session?
No, I don't.
Do you recall Ms. Smith coming to your office with those purchases?
No, I don't.
Do you recall Ms. Smith trying on those purchases for you the evening of November 2nd at her home?
No, I don't.
Were there any other patients in your office on November 2nd?
I don't recall.
Do you want to look at your appointment book to see if you had any appointments with other patients on November 2nd?
If you'd like to present that to me,
Would you like to see it?
to refresh my memory.
Look at Thursday, November 2nd.
I see it.
Are there any other patients listed for that day?
There are no other patients listed for that day.
So only Eric and Lyle were going to be seen by you that day, is that right?
Appears to be correct.
What time did the session begin?
There's no sure way to know that.
Doesn't indicate?
No, I think I just told my the person who does billing that I had seen them for that period of time, and I don't know that the space, it's written in the middle of the schedule, and I don't know that that reflects when I actually saw them.
Well, how did you know what time to be there?
I made an appointment. But-
Yes, and where is that appointment memorialized?
It's not memorialized here. I made the appointment personally with Eric and Lyle, I
Face to
believe.
face, in fact, didn't you?
I don't recall that.
You made that appointment October 31st before they left, didn't you?
I might have.
They agreed to come back October 31st before they left, didn't they?
I don't know. I don't recall it.
But you recall that you personally made the appointment. Is that right?
Recall I made the appointment, but I don't recall when it was, and I don't believe it was October 31st.
Did you write it in a book when you made it?
No,
So do you remember what time it was made for?
I think I've already testified that I don't recall what time that it was, and it may not be where it's written in this book. She was simply noting the amount of time that I spent with him.
I wasn't asking what's in the book. I'm asking about your memory, upon which you have relied to great extent in this case, have you not?
Yes, I have.
And let's talk about your memory. What time was the appointment?
I don't
You're
recall.
asking about November the 2nd, is
Yes,
that
Your
right?
Honor.
It was in the afternoon, or took place in the afternoon. I don't recall specifically whether it took place at 12:15 or 1:15 or 1:45.
What time did you go to your office that day?
I don't recall.
Where were you before you went to your office that
All right,
day?
this area has been asked and answered. Go on to something else, please.
I didn't ask for me. Huh?
Well, you had an opportunity to do that before. Go on to something else, counsel.
Now, did Eric and Lyle come together that day?
To the best of my recollection, they did.
Did you see them arrive?
I don't recall having seen them arrive.
Were you in the waiting room waiting for them?
I don't recall that.
Was it your general standard and practice to escort your patients out after a session?
There is no general standard of practice that I have with that. Sometimes I do, sometimes I don't.
On this occasion, did you walk out with Eric and Lyle after the session on November 2nd?
I don't recall.
But you do recall seeing Miss Smith in the waiting room. Is that right?
I have a recollection of Miss Smith being in the waiting room and that she was there.
And was she there when they walked out?
I think I've already testified that I don't recall. I think she was there, but I don't recall whether I looked and saw her there or not. I have an image of having seen her in the waiting room at some point in the session on that day.
How could you see her in the waiting room in the session? You're in a room, you're down this L-shaped corridor, aren't you? In a room with the two doors between you, right?
Let me clarify.
Well, let me ask you.
Okay, let's ask a question in a non-compound way, please.
Did you leave the session at some point and walk into the waiting room?
Yes, I did.
And that's when you saw her there?
At some point when I walked into the waiting room, yes, I saw her there.
Okay. So then after the session's over, do you still see her there?
She was there.
No, that's not my question. Did you see her there after The session is completely over.
Yes, I recall having seen her there.
Okay, and why did you go into the waiting room at that point, at the point when you see her there for the second time?
To leave.
Okay, so you're leaving at this point, correct?
I believe that I was leaving, yes.
And she leaves with you, correct?
I don't know if she left with me or not. I don't recall.
But didn't you go back to her house that night?
Yes, but I don't recall whether she left with me or whether she had her own transportation and drove back to her
So
house.
you don't know that?
My recollection would be that she drove back in her own vehicle, which is the reason that I said that I don't recall her leaving with me.
Or your best recollection is that you went together, but you don't want to tell us that. That's also a possibility.
Counsel, that's argumentative. Ask another question.
Now, I'd like to take you back to the date of October 31st. No, strike that. I'd like to take you back before that. I'd like to take you back to the day that you got the phone call that Mr. Kuriyama was asking you about from Eric. Okay? Recall what I'm talking about? The phone call to set up that appointment?
I recall the phone call, yes.
Did you set up that appointment, or was this somebody else, either your wife or your secretary or whoever is responsible for that?
I don't recall who set up the appointment. I recall Eric calling, and I recall me talking with Eric and the content of what Eric requested me to do, but I don't recall when the appointment was actually set up.
Well, was Eric calling to make an appointment?
Eric was calling to arrange for an appointment to be made.
Okay. And when a patient calls and talks to you and says, I want to come in and see you, then what happens to translate that into an appointment?
Generally speaking, what happens is that a secretary calls up and arranges a time to come in based upon my schedule and my availability.
Oh, a secretary calls up because you tell the secretary to call up. Is that right?
Generally, yes.
All right. So you talk to Eric, and then I take it you don't make the appointment. You tell him, well, my secretary will call you to make an appointment. Is that what happened?
I don't recall how the appointment was made.
Do you see it in the book in front of you?
Question is, does he see the appointment in the book?
Yes, Your Honor, he has the appointment book in
All
front of
right,
him.
that's not what you asked.
Yes, I see the names written in, and I don't know when they were written in.
Okay, so that appointment book is something that where entries can be made after the date of the appointment. Is that what you're saying?
If someone canceled and I told the secretary after the fact that I saw somebody at a particular time, yes. Sometimes, rarely, an appointment can be written in after I've seen somebody.
Did you carry your own personal little appointment book or week at a glance or month at a glance so that you'd know when you're supposed to be in your office to see people?
I did that on a weekly basis.
So you had a weekly sheet of some kind.
That's correct.
Can you tell me what the entries are in your book, why all those names appear on Sunday? You didn't see patients on Sundays.
I don't have any idea what her system was for names on Sunday. And no, I think those may just be people who either wanted an appointment the next week or somebody who called for some reason or just notes. I don't know what they reflect because I didn't make them.
Now, is that book relied upon to do the billing?
I don't know if this was the book to do the billing because I don't think I even recall having seen this at the time that it was seized.
You don't know?
I don't
Is that the
know.
answer? And you don't know what the system of billing was?
I know the system of billing was for me to report the amount of time that I spent with somebody if it wasn't scheduled by the secretary, but I don't know if this was in fact the book that was used.
Do you know if that list of names that appears on Sundays is the list of bills that need to go out?
No,
Or
I
the
do not
list
know
of-
that.
Or do you know if it's the list of patients for whom sessions are going to be billed that week?
No, I don't believe that that's what that list is. Doesn't make any sense that it would be.
Okay, now let's talk about the phone call from Eric. You seem to remember it. Do you not?
I think I remember the essential elements of the phone call, right?
Okay, and tell me, was Eric angry with you in that phone call?
No, he was not.
Did he threaten you in any way during that phone call?
No, he did not.
Did he tell you that he wanted to harm you during that phone call?
No, he did not.
And I think you said that he sounded very urgent.
That's correct.
Now let's talk about when Eric arrives on October 31st. Were you the only person still in your office suite at that time?
I believe I was. I know that I specifically had arranged for there to be no other therapists seeing any other patients later.
Well, I'm asking if you can remember.
I don't recall whether somebody else was in the office at that time. I don't know that I would have even known.
Do you remember what you were doing just before Eric arrived?
Well,
Do you remember?
I believe I would have been seeing the patient before.
Okay. Do you remember seeing that patient?
And no, I don't remember these. I remember seeing the patient. I don't remember that specific session I had with the patient.
Do you remember seeing that patient leave?
Do I specifically remember seeing the patient before leave?
Yes.
I don't think that I specifically remember seeing that patient leave on that day.
Do you remember whether you walked that patient out that day?
No, I don't.
Do you believe you did see a patient immediately before Eric arrived?
Yes, I do.
So do you remember now what you were doing when you first became aware of the fact that Eric was there?
I think I was sitting in my office waiting for Eric to come.
Okay. And the way you'd know that someone had arrived was some light would go on. Is that right?
Eric would have pressed a button, and the button would go on in my office that would alert me that he had in fact arrived.
Well, anybody arrives is supposed to press the button, correct?
That's correct.
That's how you know people have arrived. A light goes on because someone's pressed a button, correct?
That's correct.
Do you remember the light going on October 31st?
Yes, I do.
What time did the light go on?
Sometime around 4:15, something like that.
Did you check your watch so you could start the clock rolling?
No.
Now, when the light goes on, what do you have to do?
What I do is I open the door and go and open the door leading to the waiting room so that the patient can come in.
Okay. And you saw Eric there?
That's correct.
What was he wearing?
I don't recall.
He was, however, wearing clothes, correct?
He was wearing clothes.
And did you then return with him to your consulting room?
Yes, I did.
And did he then, you started this session with him in which he was telling you how he was feeling. Is that right?
That's correct.
And how long do you believe you stayed in your office talking to him before you left to take this walk?
I can't recall with certainty how long I spent with Eric in the actual session room before he indicated that he wanted to go take a walk.
Well, I didn't ask exactly. Can you give me an approximation? Was it 5 minutes, 50 minutes, 2 hours? Some idea.
It wasn't 5 minutes and it wasn't 2 hours.
So maybe it was an hour,
Could have been.
hour and a half?
It could have been.
And I think you've described his basic moods and demeanor from that period of time as depressed, is that right?
Yes, he was.
Lonely,
Yes,
isolated?
correct.
Beyond the scope.
Overall.
Was he crying during any part of this part of the session?
I'd have to refresh my memory by looking at my notes to see if he was specifically crying at this particular moment in the session.
Well, you didn't note in your notes times when people cried, did you?
Not always. Sometimes I did, sometimes I didn't.
Well, in these particular notes, you never noted a time when people were crying, and yet you've testified to Eric crying. At
Okay,
various
counsel, now that's an argumentative question.
Take out
Re-ask
your
it,
notes.
please.
See if-
Counsel, re-ask the question.
Do you need your notes to see?
I don't recall Eric having cried at that point in the session.
Well, did you just say you'd need to check your notes? I
said to determine whether at that specific time I should check my notes because I don't recall it.
Go right ahead.
Okay. He was definitely agitated, definitely depressed, definitely upset. I don't recall if he was crying.
Was he sad?
Yes, he was.
Was he grieving?
I don't think I can state that he was grieving or not, but he was sad.
Did he tell you that since his parents had been killed and he was removed from his family, he felt lost?
Yes, he did.
Did he tell you he didn't know if he wanted to live or die?
Yes, he did.
And did you have some concerns about him being potentially suicidal?
I did have.
And did he tell you that because his family was no longer there, he had no structure, no order, no stability in his life, and so he was turning to tennis all the time to give him those things?
Yes, he did, Ms. Abramson.
Did he tell you that he was even wondering if he might need medication? He felt so badly.
The topic of medication came up with respect to his being depressed, yes.
And did he tell you he was having really vivid nightmare dreams?
Yes, he did.
Are you familiar with even the popular literature on post-traumatic stress disorder?
Yes, I am.
And
I don't know about the popular literature. I'm familiar with post-traumatic stress disorder.
okay, well, I didn't want to ask as based on just an expert. There's been a lot of popular
I
literature
see.
about it as well, correct?
I see.
And were these kinds of dreams in which he had vivid pictures of his dead parents, did they sound like the kinds of flashbacks and things that victims of post-traumatic stress disorder suffer from?
Objection, your question.
Objection is sustained. It's beyond the scope. Next question, please.
Excuse me, are beyond the scope of direct?
Yes.
Did he describe these vivid nightmares for you?
He described bits and pieces of them, yes.
Did he tell you that they were causing him to lose sleep?
I don't recall that part of it, but he definitely described that he was having vivid, frightening nightmares.
Then after some period of time of, I think you've approximated now, probably around an hour, you went out with him to take a walk, correct?
That's correct.
And when you walked outside, it was dark, wasn't it?
Best of my recollection, it was dark,
And in
or getting
fact,
dark.
You put in your notes, it was dark on page 2, paragraph 2. Sentence 2.
It says it was dark.
Right. And it was, wasn't it?
The only way that I would know if it was dark is basically by what's stated in the notes. I think it got dark as we were walking and returned to the session. I don't think it was actually dark at the time that we left.
Let me read you the sentence. Page 2, paragraph 2, sentence 1. We proceeded to walk outside the office, period. It was dark, period. We then walked across the street and Eric went into the bathroom at the Bagel Nosh restaurant and walked into the park with me, period. Now, plain meaning of that sentence, doesn't it give the plain impression that it was dark when you proceeded to walk outside the office?
Gives that impression. But I don't believe that it was dark when we walked out of the session.
So you dictated the notes in such a way as to give false impressions, is that right?
No, that's not right.
Now, you went to the park with Eric,
That's correct.
and did you walk around the park for a while?
We walked around and mostly we sat on a bench and talked.
Before you sat, do you recall what the conversation was about?
Well, in general, the conversation was about his father. In fact, that's what most of the conversation was from the time that we left the office until we returned to the front of the office building that I was occupying.
And this was a conversation about his father and how tragic it was that his father was killed before he could fulfill all his dreams, that conversation?
It was a lot more elaborate than that, but yes, that's the basic tenor of the conversation.
And wasn't it also the basic tenor of the conversation how lost Eric felt without his father?
I don't recall his saying so much that he felt lost without his father, but he definitely was talking about how great a man his father was and how it was so unbelievable to him that his father had been cut down at a point in his life where he hadn't been able to achieve so many of the dreams and so many of the things that he might have been able to achieve had he been alive.
Did he indicate to you that he felt that was a tragic thing?
Yes, he did indicate that he thought it was a tragic thing.
At that point, when he was talking about his father, was he crying at all?
I don't recall if he was crying outside in the park. I know that he was very sad and that he looked very sad. I don't recall if I could actually see that he was crying. He might have been crying.
And how long would you say the walking, bagel noshing, sitting on the bench, walking back part took?
Well,
Approximately.
hard. I'm just trying to estimate here and
Fine.
think.
Just estimate.
That's what I'm trying to do. Probably something like an hour and a half, something like that. I don't recall specifically.
Okay. And now you go back towards your office, and before you actually enter your office again, he tells you that he and Lyle did it, correct?
That's correct.
And then you go, now, when he tells you that he and Lyle did it, that causes you some concern, does it not?
That causes me more concern than I had already had, yes.
All right, but I mean, now you get real concerned, correct?
That's correct.
And did you have in mind even then that you wanted to have some sense of where Lyle was at?
No, not then.
All right. So then you go back upstairs to your office and he begins to tell you what happened. Is that right?
That's correct.
Do you ask him what happened, or does he just start talking?
No, he just starts spilling out things. He had a real need to confess, to talk.
And it comes out very quickly, doesn't it? Very rushed.
He just started to, I don't recall how it came out. I just recall that he began revealing all the details.
And you say you don't recall how it came out. You don't recall if it's rushed or slow. You don't recall if he's crying or not. You don't recall anything?
No, I recall his manner of speech, and I can picture Eric sitting in the chair that he was sitting in, which was across from me. And I can recall him beginning to, relatively more quickly than he would usually speak, tell me all the details of what had transpired. And I do have a vivid picture of it.
And he gets it all out more rapidly than he usually spoke. Is that what you've said?
More rapidly than he usually spoke, yes.
Eric speaks quickly, doesn't he?
Section bacon.
Sustained.
Is Eric a slow talker?
You're talking about now or then, or what are you talking about?
From your experience.
You're asking about during therapy or social conversation? Be more specific.
All right. Had you talked to him both during therapy and in social conversations?
I don't know that I'd really had any social conversations with Eric.
Well, you talked to him at the Bel Air Hotel as well as in your office, correct?
Those are professional consultations.
Fine. Either way, on the occasions when you talked to him, did he seem to be a slow-speaking person?
He didn't seem to be a particularly slow-speaking person, and he also didn't seem to be anyone who particularly spoke with pressured speech, which means a very sort of rapid speech.
So he was average.
I would say maybe he was average in terms of his speed of speech, but he was speaking this particular time in a way that was relatively more forced or more quickly than he usually did, than was his custom.
And you've already told us you didn't take any notes while he was speaking.
That's correct.
And you've already told us that he himself appeared to be confused about some of the details. Specifically, you've testified he seemed to be quite confused about who shot whom.
Well, that's definitely true. That he was confused, that there was a lot of chaos going on at the moment that the weapons were being fired. It's definitely true that he told me that.
And would you claim, or do you claim, Dr. Oziel, that sitting there with this person speaking rather rapidly and you not taking notes, are you claiming that you got every single detail down just right? Are you claiming that?
I would never claim I got every single detail down just right. I think that's an extreme statement, and no, I wouldn't make that statement.
And isn't it true, in fact, that, strike that, You have testified in response to certain questions from the prosecution in this case about these details as Eric gave them to you. You recall your testimony on direct that way. They asked the
Yes.
question, did he tell you this? Did he tell you this? Did he
That's
tell you this?
correct.
All right. Now, I want to turn to that portion that where you testified that Eric told you at some point that after having a discussion with his brother about how much better their lives would be without their father, at that point, after they had concluded that discussion, they went to San Diego and bought guns. Now, is that what Eric told you?
Yes, that is what Eric told me.
And based on the notes that you have in front of you and that I have in front of me, the way you have related that sequence, there is no time between the discussion about how awful their father is and that they should kill him, and they're going to San Diego. There's no break. Isn't that true?
Are you asking me whether the notes specify the time or whether I remember the time?
No, I'm asking you that don't the notes give the impression that there is no break between the discussion and then going off at that point, I think were the words you used, to drive to San Diego, obtain false identification, purchase 2 shotguns, et cetera, et cetera.
I don't know what impression the notes give.
Let's read it.
No, I'm reading what I've written.
The notes, well, let me.
That wasn't what I intended in writing it. Let me just state it that way.
All right, fine. You testified here that the purchase of the shotguns was, you believe, 1 week before the killing, correct?
I believe that I testified it was a minimum of a week, but I think I also have testified that it could have been as much as 3 weeks or more. But it was a minimum of a week, and that I'm absolutely certain of.
You're absolutely certain that the purchase of the shotguns was a minimum?
No. I'm sorry. Not the purchase of the shotguns was an absolute minimum.
Why don't you listen to the question? Let me do this, okay? We'll get out of here much sooner. Did you testify here that the purchase of the shotguns was 1 week before the killings? That's all I'm asking.
This states testimony.
Sustain.
Well, you're now
Why don't you read it to him?
testimony.
Read the question and the answer.
61. Let me get you the exact page. Starting at 9355. Let's start with just the sentence on page 1, on line 1. And then it goes through again to 9356.
Can we read them all, please?
Does the court want the sites?
Sorry?
I'm sorry, would the court like the sites?
Unless there's a dispute, I don't need it. No. All right. Have you finished reading it, Mr. Carrion?
Yes, sure.
Okay. All right, I would like to read you the following testimony. This is from (9355), starting with line 1, the first whole sentence. This is your answer to a question. So they had agreed that they would commit the murder and they were negotiating how soon to do it. After that point, what they did, and I believe to the best of my recollection, it was something like a week or so before the murder. Question, wait, hold it right there. This discussion about planning the murder occurred 1 week before the actual murder? Answer, that's the best of my recollection. Question, approximately? Answer, something like that. Then there's a objected to question, and now we go back to line 26. Question, this discussion that Eric Menendez related to you that he was having with his brother Lyle about planning the murders of their parents, is it your understanding that this discussion, by what Eric Menendez told you, occurred about a week before the actual killings? Answer, it's my understanding that it occurred at least a week before, based upon my recollection. At that point, what they did, according to Eric, was drive to San Diego, et cetera, et cetera. You remember that testimony?
Yes, I do.
Now, you're testifying, are you not, that at the point that they're having this discussion, or at the point that they have this discussion about planning, et cetera, they then drive to San Diego and buy guns, right?
No.
No. How long before the parents are killed, if you know, did Eric say they bought the guns?
I don't recall that, but I do recall when.
But I'm asking you that. If you don't recall it, is that your answer?
I don't recall. He just told me that they.
There's no question.
Yes, the answer was you don't recall.
Okay. Sorry, Your Honor.
Now, there is, let me read you page 3, paragraph 2. Okay? I asked you before, didn't you write these notes in such a way that it looked like the discussion led directly into the purchase of the guns, which led directly into the shooting? That's how you wrote these notes, didn't you?
That's a compound question. Ask it again, please.
Did you write these notes in such a way that you are indicating there's a discussion between Eric and Lyle? There is negotiating because Lyle wants to wait a week and Eric says he cannot. There is a decision, therefore, at that point to go to San Diego and buy guns, which they do. And then they come back and kill their parents. Isn't that the way you wrote it?
No.
Well, then let me read this to you. Page 3, paragraph 2. At that point, apparently, or at one point, Lyle simply turned to Eric and said, well, do you have the emotional ability to do this? Eric said he realized at that moment that they were making a clear decision to engage in the murder, and he told his brother yes, that it had to be soon, and it could not be delayed. Lyle apparently wanted to wait a week to plan it out more thoroughly. Eric decided that he didn't have the emotional ability to wait. Apparently, what the two sons did at that point was to drive to San Diego, obtain some false identification, purchase 2 shotguns with the false identification, drive back to Los Angeles, et cetera, et cetera. Isn't that what you dictated?
Yes, that is what I dictated.
And didn't you testify before the grand jury a year ago that you were very fuzzy about the timing?
I believe I said I was fuzzy on the exact timing of what the time period was between the plan and the actual murder, and I think I gave a span of time.
Didn't it? But the question was, did you testify you were fuzzy about the time sequence?
No, I believe I testified that I was.
Is your answer no?
No.
Did you testify before the grand jury in August, December 7th, 1992, that you had no clear recollection of the timing as described to you by Eric?
I don't recall whether I testified in that manner or not.
Would it refresh your recollection if I show you a question and answer that you gave at page 351 of the grand jury transcript?
It probably would.
Yes.
Did you read this to yourself?
I just did.
Let me, just to make sure you're clear on my question. Were you also asked before the grand jury the question about whether Lyle wanted to wait a week? Do you recall being asked that?
Yes, I do recall that.
And do you recall at that time saying, to the best of your recollection, Lyle wanted to wait, I think, a week to plan it further? I don't recall whether it was a week exactly, but that is to the best of my recollection. Recall that?
I recall having testified that way, I believe.
Okay. And do you recall being asked your impression was 7 days approximately, and you said, uh-huh?
I don't recall that, but sounds consistent.
And do you recall being asked, and Eric indicated he didn't want to wait that period of time, and you answered yes. I believe it was a week in relationship to planning it more thoroughly, moving ahead with it. Do you remember that?
Yeah, I do remember without respect to whether I remember that testimony that Eric definitely
No, I'm asking
didn't want to
about
wait.
your testimony.
Okay, I don't recall that specific testimony.
And then you recall being asked, do you have any clear recollection on the timing? And you said no. Correct?
That's not the sequencing in the transcript you showed me, but at some point that was in fact asked me, but not in the sequence that you're describing.
Now, what is your best recollection now of the period of time between when Eric and Lyle are discussing this and the time when they buy the guns? If you have such a time period.
I think that you're asking a question that's too vague for me to know what you're talking about. Could you ask me a clearer question?
You said they had a discussion and they made something of a decision. I've just read that to you from your notes, correct?
That's correct.
And how long after they make that decision do they go and buy the guns, if you know?
I do not know how long it was from the time that they watched this show.
I haven't asked you about the show. I'm
Okay.
asking about the discussion.
Well, the discussion was linked there was an ongoing discussion, but it didn't take place at one point in time, Ms. Abramson.
But you said there was a time, and you said this on direct, and Mr. Kuriyama asked you, was there a time when they were negotiating whether to wait a week or not?
Yes, but that negotiation didn't take place at one moment in time. It was an ongoing negotiation.
So for a period of many, many weeks, they were negotiating whether to wait a week. Is that what you're saying?
Objection sustained. Re-ask the question, please.
Are you saying that they argued about waiting a week over a period of longer than a week?
No, I didn't state that, Ms.
All right, then
Abramson.
let's talk about when the discussion about waiting a week took place with respect to the purchase of the guns. When did that discussion take place?
I don't recall and don't know that Eric ever specifically told me what the time frame was or the interval between the discussion about waiting a week and between the actual purchase of the guns. So I could not testify with any specificity about the interval between the final decision to go ahead with the actual murder and the time that they actually bought the guns.
Fine. Now, can you tell us then, can you answer the question about how much time passed between their buying the guns and the shootings, if you know?
I do not know, or I did not know at that time anyway, what the time period was.
So when you testified here that the discussion occurred a week before the killings, you were in error. Is that correct?
Let's be specific about, so I think the problem is you're asking me about discussions, and they had a lot of
Do
discussions.
you not understand the question?
I think you haven't asked me a specific enough question for me to be able to testify with accuracy.
Do you not understand what I'm asking you about?
Why don't you just ask another question?
Let me read to you your testimony starting on 9354. Stand by. 61. 9354, starting with line 19. Now, here's what you testified to on Wednesday, August 4th, 1993. Okay, well, Eric relayed to me at the point that he and Lyle had discussed planning the murder that Eric felt a need to commit the murder relatively quickly, or he basically thought that he would lose the emotional ability to commit the act. Lyle, according to Eric's recounting, wanted to take some time to plan it out more effectively, to make sure that it was as perfect as could be. And Eric just didn't feel that he could, it's a word missing, point that. So they had agreed that they would commit the murder and they were negotiating how soon to do it. After that point, what they did, and I believe to the best of my recollection, it was something like a week or so before the murder. And Mr. Kuriyama interrupts and says, wait, hold it right there. This discussion about planning the murder occurred 1 week before the actual murder. Answer, that's the best of my recollection. Question, approximately? Answer, something like that. Question, okay. Answer, what they did at that point, I should clarify, it could have been a week. Then there's some objections. Mr. Kuriyama asks you, 26, this discussion that Eric Menendez related to you that he was having with his brother Lyle about planning the murders of their parents, is it your understanding that that discussion, by what Eric Menendez told you, occurred about a week before the actual killings? Answer, it is my understanding that it occurred at least a week before, based upon my recollection. At that point, what they did, according to Eric, was drive to San Diego, etc., etc. Remember that testimony?
Yes, I do.
Dr. Oziel, you were certainly interested, if nothing else, when you heard that the Menendezes were killed, correct? Definitely got your attention.
I wouldn't state it that way. I would say that,
Well,
of course, I was interested. I cared about Eric and Lyle, and of course I would have been interested.
All right, you were interested. And you knew, did you not, because you heard it from the media, that the killing of these people was receiving media attention, correct?
I don't think that was anything that I was focused on at all, but
I didn't ask if you were focused. I asked, did you know?
well,
It
it was on television, so I knew it was on television.
All right, objections overruled.
It was on television. It was in the newspapers, wasn't it?
Yes, it was in the newspapers.
It was on hard copy, wasn't it?
I didn't watch hard copy.
Were you sufficiently interested, since you knew these people, to read the newspaper accounts?
I seem to recall having read the newspaper account, and I definitely was informed the day that the murder was announced on television. So, yes, I knew about it.
And do you recall seeing a lengthy piece about this case, about the parents, not about the arrest of the boys? Do you recall seeing a lengthy piece in the Los Angeles Times Sunday magazine in October of 1989?
I don't really recall that.
You don't recall ever seeing that piece?
Well, I think there was a piece, but I don't recall anything particularly. I really don't read very much about this.
So you didn't read about this even though you knew all the people involved. Is that what you're saying?
I'm saying I don't recall having read that.
Do you recall reading the ordinary news stories about the investigation of this homicide during the months of August, September, and October of 1989?
I don't recall my focusing a lot of time on reading any particular articles. I'm sure I did, if I saw an article on the Menendez case, read it. I just don't remember how many articles I saw on the Menendez situation.
And do you recall reading in the early parts of the in the early stages of the investigation, do you recall reading in the newspaper that all the casings were picked up at the scene? There were no shot shell casings left behind by whoever did the shooting.
I don't know that I recall that. I don't recall it.
And do you recall there being in the publicity mention of the fact that it was the sons coming home that reported the killings to the police?
I don't recall that, but I think
Is
that
your
I had.
answer no, you don't recall?
No, I don't recall it. I don't recall it from the newspaper, no.
Fine. Now let's turn to October 31st. Before Lyle gets there. And I want to turn your attention to page 5, paragraph 2. Now, you testified on direct, I believe, that Eric told you on October 31st that he was beginning to have difficulty with the fact that he might be inheriting a great deal of money. Is that what your statement was?
Yes, it is.
In your notes, however, you wrote Eric had more and more difficulty dealing with the fact that they were going to be inheriting a great deal of money, correct?
That's correct.
In fact, what he's telling you is that he's had difficulty about that from the very beginning.
Objection, misstates the testimony.
Sustained.
Well, isn't that what he's telling you there?
What is the question?
Yes.
Isn't the question not that he's just beginning to have difficulty, but he's having increasing difficulty, so the difficulty precedes the present tense when he's telling you this?
I don't know. My feeling at the time was that Eric was having a lot of difficulty with the issue of the inheritance of money. I don't know if he stated anything to me that related to how soon in time he began to have those feelings of guilt. But he definitely was having a lot of trouble with that.
Go right ahead, don't mind my bad.
Yes.
With that aspect, is that correct? He's
Yes, he was having a lot of trouble with
the
that.
notion of getting money.
That's correct.
And didn't he emphasize to you that the killing wasn't for the money?
Is that the end of the question?
Yeah?
Oh, okay. Yes, he did.
And didn't he even think that there might have been a recent will in which they were disinherited, or at least he was disinherited?
Yes, I think that that he was making the point very clearly at this point in the session that not only was the money something that he was feeling extremely guilty about, but he thought that he might have been disinherited in any event.
Before the killing, he thought he was disinherited. That's what he told you, isn't it?
Well,
Is that what you're saying right now?
my recollection is that he definitely, before the killing, thought there might have been a will in which he was disinherited.
Okay. Now, this appears, what you just testified to about his emphasizing it wasn't for the money, that he thought there might be a recent will. This appears right in your notes on page 5, paragraph 2, correct?
Yes, it does.
Now, you did understand as of October 31st, 1989, did you not, Dr. Oziel, that Eric didn't have the $15 million yet?
Yes, I understood that he didn't have $15 million.
And you also knew that he'd have at best half of that.
Well, I wasn't even thinking in terms of how much he would or he wouldn't have, frankly.
And he also told you, did he not, that the $15 million was an initial estimate of whoever was in charge of estimating the estate?
He went through some discussion of how he got to the figure of $15 million.
Well, he told you there was a lawyer for the estate and other advisors, and that's what they're telling him, right?
He told me some other things as well. that related to life insurance policies and key man insurance and so on and so forth that added up the amount of money.
Do you think the key man life insurance pays to a family? Is that what he told you?
I don't have any idea what key man life insurance does or doesn't, but I do recall Eric having spoken specifically about different aspects of how they got how we came up with the $50 million figure. But
Okay.
I don't have any idea what key man insurance does and doesn't do.
Well, didn't you read about that in the newspapers also, about this huge insurance policy that the company had that they got?
No, actually, I don't recall having read that in the paper. I recall very specifically Eric
So your
detailing
answer is
that.
no, you didn't
Objection,
read
Your Honor.
it. Is that correct?
Yeah, had you finished the answer?
I don't know. She. cut
Let's
me
have
off
the reporter read it
midstream.
The answer, Your Honor?
Yes.
Answer, no, actually, I don't recall having read that in the newspaper.
That was responsible.
Was that your answer?
That was part of my answer. Did you want me to complete the answer?
No, we can get.
Well, I would
another
object to anything else, Your Honor. That was responsive to the
Counsel, your
question.
next question.
Thank you, Your Honor. Now, after discussing this, the business about money and disinheritance, did Eric then, or did you and Eric engage in some kind of discussion about potential evidence?
I recall Eric having told me about the potential evidence, but I thought it was prior to.
Well, why don't you look at page 6?
Mhm. Oh, yes, okay.
Okay?
Well, there was a discussion both prior to and subsequent to this. There was also one on page 5.
Let me ask you something. We're now at page 6 of these notes, and the section of these notes that has to do with Eric going into your office and then starting to tell you the details, that begins at the very bottom of page 2. Is that correct?
I believe so.
Okay.
Let me take a look. Yes, it begins at the bottom of page 2.
Okay, and now we're at page 6, and there's a discussion here about fingerprints and weapons, et cetera, correct?
That's correct.
At any time during this discussion, are you saying anything to Eric, or is this still, he's just spilling it all out?
No, I'm talking with Eric or asking him, what he was feeling or what happened or whatever at different points throughout this time.
So it's a conversation.
Well, it's a therapeutic conversation.
But it's you're talking and he's talking, correct?
That's correct.
Now, after he has this discussion with you then about lack of fingerprints, no witnesses, all of that, did you form the opinion or come to the conclusion that after this discussion about lack of evidence, did you conclude that they, meaning Eric and Lyle, had basically a perfect situation where no one would discover them? The only weakness would be if someone knew information that both Lyle, Eric and I, or anyone else for that matter, who had the information would be in danger. Did you conclude that it was perfect and the only weakness was if someone like yourself knew?
Eric concluded that previously.
Calling court and counsel's attention to transcript of June 15th, 1990, page 36. I propose to read, well, I can start with 21 and just keep going.
No, this was read in cross-examination.
No, it was stopped because,
All right,
An objection.
counsel, if you want to approach, we'll discuss it.
When you approach.
well, can I have volume 65?
That's where you were.
Thank you, Your Honor. Okay, let me read you an answer you gave in June of 1990, page 36. Well, before I
Why don't
called
you read the
Lyle.
question as well?
All right, question. And when did there occur what you perceived to be a direct threat? Answer. Well, before I called Lyle, Eric made the statement that if Lyle knew that anyone had information about this, I concluded that they had basically a perfect situation where no one would discover them. The only weakness would be if someone knew information that both Lyle, Eric and I, or anyone else for that matter, who had the information would be in danger. So I felt in danger, absolutely, the moment Eric told me of the events that occurred. Remember that testimony in June of 1990?
No, but that's not inconsistent with what I'm stating today.
Well, would you let us decide what's inconsistent for a change?
Okay.
All right, let's not argue with the
Now,
witness.
let me, I think I had previously, before I was stopped by my co-counsel, back last Friday, I think I previously asked you to look through your notes of October 31st and see if you could find anywhere in those notes, prior to the time that Lyle arrived, whether Eric ever used the expression perfect murder. Do you remember my asking you to do that?
Yes, I remember that you did.
And do you remember that you did look through the notes and there was no indication in the notes that Eric ever used the phrase perfect on October 31st before Lyle arrived, correct?
Incorrect.
Incorrect? All right, show me where it is.
No, incorrect that it wasn't mentioned, correct that it's not specified in the notes.
So another one of those things that 4 years later you just happened to remember, but you left it out of the notes. Is that correct?
No, that wouldn't be an accurate statement of it at all. It was repeated regularly, and the reason I recall it is because it was regularly repeated.
Regularly repeated by Eric before Lyle got there, but not worth a single entry. Is that what you're saying?
I think I've testified numerous times that these dictated notes were not intended to be an entire complete record of all 8 hours that I had with Eric and Lyle Menendez over those 2 days.
Dr. Oziel, is there any place in these notes of October 31st before Lyle arrives where Eric uses the word perfect, according to these notes, anywhere?
No, not in those notes.
Thank you. But you, in your mind, decided it was perfect, didn't
Objective,
you?
argumentative.
Objection sustained. Counsel is arguing with the witness.
Did you decide in your own mind that it was a perfect situation and the only weakness would be somebody knowing? Did you decide that, as I've just read to you?
At some point, it seemed reasonable that what Eric was characterizing as being a perfect murder did indeed seem to be a perfect murder based upon what he relayed to me about the lack of any evidence or anything to tie either he or Lyle to the crime.
Is that yes, you concluded it was perfect in your mind as well? Is that what you're saying?
Based upon what Eric told me at some point, I concluded that it seemed to be a quote unquote perfect murder.
And that's before Lyle got there that you concluded that. Is that correct?
I can't specify the exact point in time when I concluded that.
Well, when I read you from June 15th, 1990, do you think perhaps your memory back in 1990 of when you concluded that was better than your memory now of when you concluded that?
I don't know, without you repeating the statement, whether my memory is better now or then. And
Is your answer, I don't know?
I don't know.
Well, let me read it to you again.
That's fine.
Well, this is page 36, line 21. Well, before I called Lyle, Eric made the statement that if Lyle knew that anyone had information about this, I concluded that they had basically a perfect situation. You want me to keep reading, or does that refresh your memory again?
No, but that was after Eric had already described to me very elaborately why it was a perfect murder.
Was this before you called Lyle? That was my question.
Yes, at some point before I called Lyle.
Thank you. Now, Can you tell me before you called Lyle, what words of threat did Eric use against you?
Eric used no words of threat against me before I called Lyle.
And what words of threat did Eric use against you after you called Lyle but before Lyle arrived?
Eric used no words of threat throughout the entire 1031 session. He did not threaten me specifically.
He didn't threaten you unspecifically either, did he?
No, I did not feel threatened by Eric in the 1031 session.
And yet you told Judalon Smith the things that Eric had told you, didn't you?
I told her the things that Eric and Lyle had told me because
I can ask you why. The question is, Eric didn't threaten you, and yet you told his confidential communications to your girlfriend, correct? Is that right?
You're not letting me answer, Ms. Abramson.
I'm asking you to answer the question.
You're not-
I'm asking
you're not
you
allowing me to answer it.
explain.
You're not
Okay,
allowing me to
number
answer.
one, ask the question again in a non-argumentative fashion.
All right, first of all, it's true, is it not, Eric didn't threaten you at all on October 31st, correct?
It's
We've been through that, so ask
All right.
the question.
Isn't it further true that you told Judalon Smith things that Eric told you confidentially on October 31st?
Yes, it is true. Well, no, I don't perceive that they were confidential because of the threat.
Well, but he told you things before there ever was a threat. Surely he understood they were confidential at that point, so did you.
Counsel, is that your testimony at this point?
At the time.
Counsel, do you want to withdraw that question and ask another one?
Yes, I am asking another one. I
Okay,
assumed that
you
the court
want
was
to honor the court's objection and you
course.
want to honor the court's ruling and you want to ask another question.
Yes.
Okay, ask it again.
Okay.
Another question.
Now I've forgotten what it was.
That's probably good. Go on to something else.
So, okay, you're going to have to give me a minute. At the time when Eric is telling you these things, is there anything that's happened between the two of you that you've communicated to him that would lead him to believe that when he's talking to you alone, that these are not confidential communications?
Not that I'm aware.
So what he's telling you are secrets at this point, are they not? At the point when he's telling you?
Objection vague as to at which point she's speaking about.
Sustained.
Before Lyle ever gets there, before there's ever a threat, everything that Eric's telling you is part of the therapeutic relationship, is it not?
I think that he perceived that, yes.
Well, if you perceived it any differently, you certainly didn't tell him anything to the effect that it wasn't confidential before Lyle got there, did you?
Sustained.
Did you tell him that it wasn't confidential before Lyle got there?
No, I didn't.
So what happened is Lyle gets there and he threatens you, and that blows Eric's confidentiality. Is that what happened?
Objection misstates the testimony.
Sustained.
Well, Lyle gets there. Eric doesn't threaten you on October 31st, correct?
Eric didn't verbally threaten me on October 31st.
Eric didn't threaten you in any way on October 31st, did he?
The fact that Eric and Lyle were sitting and talking in the Jeep, and Lyle was telling me that what he was going to do basically was to talk about, or implying to me very strongly that he was going to be talking about killing me, and he was talking with Eric about it, definitely led me to believe that Eric and Lyle were sitting in the Jeep talking about killing me, which in fact they were.
Well, you didn't know that on October 31st. They didn't tell you that to November 2nd. Isn't that true?
It's true I didn't know it for a fact, but I clearly must have been correct about what I was perceiving because that's exactly what they were doing.
Well, that's because you're a very smart person. Isn't that right, Doctor?
Counsel, let's not argue with the
Let's
witness.
get back to October 31st. Eric runs out of the session when Lyle is threatening in tears, doesn't he?
He had his head in his hands.
And he was crying.
I believe he was crying at the moment.
You've
he walked out.
testified twice before he was
I
crying.
said I believe he was crying.
Right. He cries and runs out because his brother is angry and upset, correct?
His brother was, I wouldn't characterize him as only being angry and upset.
Well, at least he was angry and upset.
That would not be a complete statement, but yes, he was probably angry and upset in addition to a lot of other things.
And Eric runs out of the room in reaction to his brother being angry and upset and any number of other things you may ascribe to him, okay?
Okay.
Then he doesn't threaten you on his way out of the room, does he?
Who is he?
Eric.
No, Eric didn't threaten me.
And you go downstairs later, and Eric's sitting in the Jeep, and you have some further brief conversation with Lyle, correct?
That's correct.
And then you go back in your office, and you don't see them again that night, correct?
No, that's not correct.
When did you see them again?
Well, I saw them sitting in the Jeep.
From where?
The best of my recollection, I may have seen them sitting in the Jeep from my office.
You may have. In fact, you were asked about that and said you had no recollection of looking out the window or looking down or seeing them in the Jeep. Wasn't that your testimony?
I don't recall. I said I may have seen them in the Jeep.
Well, did you or didn't you?
I don't recall.
So if you don't recall that you saw them in the Jeep, then you can't recall, can you, that you thought they were sitting there talking?
Objection argument.
Sustained.
If you didn't see them, how did you know they were sitting there talking?
I knew that wherever they were, based upon what Lyle had just said to me, he had basically told me that he was going to go off to discuss murdering me with his brother. And he
Oh,
didn't.
wait. You're saying he told you, that's the first time you've ever said that.
Counsel, again, would you look at me and answer my question? Is there some reason why you have to recite things that are not in the form of a question to the witness?
Well, maybe because I'll get a more accurate answer that way, Your Honor.
All right, well, then you'll be foreclosed from asking questions if you can't ask them in a lawyer-like way, in a professional way. So if you want to continue asking questions, do so in a non-argumentative fashion.
Thank you, Your Honor. Dr. Oziel, did you ever state to anyone before that Lyle said, I'm going to go down and talk to my brother about murdering you? You ever used those words ever before?
I communicated that content, but I stated that he did not use those words, and he did not say, I'm going to go downstairs and talk to my brother about murdering you. But the words he used basically communicated the same concept.
To you. Is that right?
Clearly to me, it wasn't anyone else who was receiving it.
This was your impression.
It was my very strong belief, which turned out to be correct.
Well, whatever it turned out to be, that depends on us believing you as well, does it not?
Objection argument.
Objection sustained.
I'll withdraw. On November 2nd, you claim in your notes and in your testimony that the boys told you about a discussion they had and laughing about it in the Jeep. Is that right?
That's correct.
All right. So in order for you to be right, you have to be telling the truth, both about October 31st and November 2nd, correct?
Objection argument.
Objection sustained.
There was no one else who heard this conversation on November 2nd, was there?
No, there wasn't.
There was no one else, according to you, who heard the conversation of October 31st, correct?
No, there wasn't. I disclosed the contents of it, but there was no one else who heard it, to the best of my knowledge.
Now, according to your notes, page 7, the only thing you ascribe to Lyle, and this is the last clause of the first paragraph. And this is something Lyle says to you after Eric stomps out of the room, I believe is how you characterize it, okay? Now, do you see the last clause? Lyle said that he was going to go get his little brother and talk with his little brother. Do you see that? The last clause.
I see the clause, counsel, but it's absolutely not true that that's the only thing he said to me at all. There's
But it is
a full page of this that he said to me.
All right, but I'm talking about what he said about going to talk to his brother. You said, he said that he said.
Okay, counsel, now you are arguing again, and if you want to continue any questioning, you'll have to pursue it in a non-argumentative fashion.
I'd like a brief recess, Your Honor, and then I can be more patient.
No, you'll have to proceed
Well,
right
I'd like to
now.
approach.
You're going to have to ask your question now, counsel, in a
I'm physically
non-argumentative fashion.
uncomfortable. I am physically uncomfortable. I'm asking for a brief recess.
All right. How long did you expect the examination to be? You said you had about 3 or 4 questions when you were up at the sidebar.
Yes,
And
and
how long do you expect the examination to be?
have 5 minutes if I can get answers.
All right, 5 minutes with or without answers, you're going to be finished with this witness. So we'll take a recess, ladies and gentlemen. We'll resume at 15 minutes to the hour, and which time we'll resume for a brief further cross-examination. Then the people have an opportunity for direct examination. Then we'll complete with this witness. All right, your next question, please.
Was it your belief, Dr. Oziel, on October 31st that Eric and Lyle left together in the Jeep?
Yes, it was.
How did Lyle get there?
He walked.
he walked?
To the Jeep?
No, how did he get to your office?
Oh, I have no idea how Lyle got to the office.
Was your belief, was it not, that the Jeep belonged to Eric?
Yes, it was.
And it was your understanding that Eric got to your office somehow around 4 something,
That's correct.
and Lyle got there around what time?
Significantly later.
Okay. So did you think at all that night that Lyle had to have had another way of getting to your office?
You know what, Miss Abramson, I really didn't.
Okay. You were pretty upset at the point when they left, is that correct?
That's correct.
And would it be fair to say that perhaps you weren't doing your most clear thinking at that point?
I would say at that moment, I was definitely not doing my most clear thinking.
Now let's go to November 2nd, towards the end of that session, and to guide you, would you look at page 16? At the end of the session of, well, strike that. Based on the communication that was going on and what you were observing between Lyle and Eric on November 2nd, did it appear to you that Lyle was very protective of Eric and concerned about the fact that Eric had told you?
Yes, that's correct.
And had Lyle made it clear to you that he would want to be regularly involved with Eric's therapy with you?
That's also correct.
And did the impression you get was that Lyle wanted to make certain that his brother did not disclose any further events to you or details to you that Lyle didn't want him to disclose?
Objection calls for speculation.
Sustained.
Did you have a sense, based on the way the conversation was going, that Lyle wanted to control or was trying to control the information?
Objection
calls for
is sustained.
Did Lyle say anything about his wanting to control information?
I don't recall any specific things he said.
Did he interrupt when Eric, but he looked uneasy when Eric would talk about specifics?
That's correct.
Did you detect, as just comparing these two sessions, October 31st when you're alone with Eric, and November 2nd when you're not alone, when it's you and Lyle and Eric, was there any difference in the way Eric talked to you? Was he as open? Was he less open? Can you tell us?
He was less open when he was with Lyle.
Now, you've testified, I believe, that before Lyle arrived, Eric said that he was afraid of his brother knowing that he, Eric, had told you about the killings of the parents, correct?
That's correct.
And ask you a two-part question. Did he express that he was, first of all, afraid that Lyle would be very angry with him?
Yes, he did.
And second of all, did he make the statement, Lyle will kill me?
That's correct.
And because of the way the statement was made, were you clear on whether he really thought Lyle would kill him or whether that he was using that as a figure of speech?
Objection calls for speculation.
Sustained.
Well, was there anything in the tone or in his look or in his demeanor that convinced you that he believed or was saying that he thought his brother would actually kill him?
It's a compound question. Objection sustained.
You put in your notes some reference to that remark by Eric, did you not?
Yes, I did.
You couldn't tell, could you, from the way that he said, strike this, from the way that Eric said, with reference to Lyle, he'll kill me, you couldn't tell if he was being serious or not, could you?
I couldn't be certain that he was being serious, but my inclination was to believe based upon what he had already told me, the tone of his voice, and
This is speculation.
Objection sustained. The entire answer is stricken.
Did you ask him if he was being serious or if he was just using a figure of speech?
no, I didn't.
Now, is it true that when Lyle came, he expressed anger towards Eric for Eric having told you?
Yes, he did.
And he expressed the fact that he was upset that Eric would tell you without clearing it with him first. Correct?
Among other things, yes, he stated that.
And was Eric making, when Lyle was there and was upset and was saying these things, was Eric saying anything to Lyle to justify himself? In other words, I had to tell him, or I wanted to tell him, or no, it's okay that I told him, or anything like that?
He did initially make some statements about I had to tell him things of that nature, but after the initial protestations by Eric, Lyle continued to get more and more upset and more menacing, and at some point, pretty quickly after he began to object, Lyle just took over and pretty much began making the menacing statements. And from that point on, Eric didn't state anything much else.
But Eric basically was quiet and just got in what appeared to you to be increasingly more distraught and upset.
He got more and more upset as Lyle got more and more menacing. And then at some point he just was very upset, had his head in his hands. I remember that image vividly, and he bolted out of the room.
And you didn't have any further conversation with Eric that night, correct?
I had no further conversation with Eric.
Except perhaps there was some conversation about arranging for the next session, you're not sure?
No, I didn't have any further conversation with Eric at all.
Okay. Now, you testified that both, on November 2nd, both Lyle and Eric commented frequently on how perfect the appearance of their family was to the outside world. Remember that?
All right,
Yes,
that's
sir.
been gone into, it's been asked and answered. The answer is stricken.
I haven't asked it, Your Honor.
It's been an area that you could have inquired on during your cross-examination of the witness. This is regarding the conversations that took place when the Eric Menendez jury was in the courtroom and during that direct examination. That's a subject to this cross-examination.
I'm sorry, I didn't realize that. Well, let me skip that to the next thing. Did, at the end of the session of November 2nd, both Eric and Lyle still appear to be very confused about whether their family was a successful family or failure, a family to emulate, a sick family? Did they seem really confused about that?
Objection calls for speculation.
Sustained.
Well, did they say things? Did they continue to talk about the family?
This is the November 2nd session.
Yes, Your Honor.
Both defendants present. Is that what you're asking?
Yes, Your Honor, but I have not
All right.
cross-examined on this.
Well, you could have. Objection is sustained.
Well, may I
The court
approach?
sustains the court's own objection as to being asked and answered, an area that was covered prior.
I'd like to make a record.
Okay, you may do that.
May we approach that?
Yes.
Computer? Thank you.
And it's been reported that this will be the last question by Ms. Abramson.
Much to the court's thrill. Okay. Dr. Oziel, up to the end of the November 2nd session, did both Eric and Lyle continue to talk about the family as being a successful family?
They continued to talk about it as being a successful family and also talked about it as being a family that was a sham. They stated two very conflicting things about the family.
Thank you. I have nothing further.
Redirect.
Thank you, Your Honor.
Dr. Oziel, would it be fair to say that on October 31st, 1989, Eric Menendez was feeling guilty about what he had done?
Yes,
In
that's
fact-
absolutely true.
In fact, looking at page 5 of your notes, did he tell you that the guilt was overwhelming, that he had to come in and tell you?
Yes,
Further, that he felt depressed?
yes,
And directing your attention to page 2, he began to talk about how he and his brother had planned the murders. Is that correct?
that's correct.
Yes.
It's the last paragraph, page 2. Dr. Oziel, in your notes, do you indicate
Object to that, Your Honor. Let's see. The reference.
All right, did you ask the question as a quotation, Mr. Kuriyama, or
no, just as a summary
paraphrase?
of how the conversation began about the planning of the murders?
All right, what was your question then?
The question is, Dr. Oziel, on page 2, the last paragraph, is that where you relate where and how Eric Menendez starts to explain to you how he and his brother had planned to kill?
That's where the beginning of that discussion takes place.
Dr. Oziel, would you describe what it was that Eric Menendez first told you about how the planning, how the idea of killing their parents first began?
Objection, Your Honor, beyond the scope.
Let's have the question read back, please.
Question, Dr. Oziel, would you describe what it was that Eric Menendez first told you about how the planning, how the idea of killing your parents first began?
Overruled.
Well, Your Honor, I'd like to object on it.
No, overruled.
You may answer, Dr. Oziel.
Eric told me that the discussions began with Eric watching a movie on the BBC that related to a theme that someone in the movie had a similar relationship with his father, whatever, and apparently killed the father in the movie. And somewhere in the midst of that movie, Eric called Lyle in, and Eric related, as I recall, that sort of a casual conversation to begin with, where the conversation was something like, well, I wonder what it would be like if, the person who did all this in our life was, gotten rid of, or wasn't here anymore, or eliminated, or wasn't around anymore. And that is how the initial discussion of planning to kill the parents began. But
All right, you've answered the question.
Okay.
Your next question, please.
With respect to this movie that Eric said that he watched, that Lyle later came in to watch, what in particular did he say about the movie by way of identification of the particular movie?
Your Honor, I would object again as beyond the scope of policy.
Overruled.
he just said it was on the BBC.
When he said it was on the BBC, what sense did you make out of that? What did that indicate to you?
Objection calls for speculation.
Sustained.
Are you familiar with?
Objection, Your Honor. I'd like to approach. I think I know where counsel's trying to go.
Well, if you're asking about any particular programs on BBC, objection is sustained.
I'm just asking what Dr. Oziel understood BBC to mean. That is, what are the initials?
Well, why don't you ask the witness whether that was the way it was referred to in the conversation?
Specifically, Dr. Oziel, did Eric Menendez use the initials BBC?
Yes, he did.
And what did you understand that to be?
Objection calls for speculation.
Sustained.
Are you familiar with the British?
Objection, Your Honor, if counsel's now going to suggest something.
I haven't heard the question yet.
Well,
You may ask the question.
Is it your understanding that BBC stands for the British Broadcasting Company.
Objection, Your Honor, what the witness's understanding is.
Objection sustained. It is irrelevant. Mr. Kurama, you may go on to your next question, please.
Now, the similarity between this father on this BBC show and Eric Menendez's father, according to Eric, did he indicate to you any specifics about the similarities?
Objection, the only spoken for.
Overruled.
Yes, he said that the father in the show was very similar to their father. And he didn't get into a lot of elaborate detail about how they were similar, but he said that apparently a character in this movie killed his father, and that's when he called Lyle in to make Lyle aware of what the plot was. And it was in this movie, apparently, while it was going on, that they began talking about what would happen if they decided to do something similar with respect to their father.
Now, with respect to what Eric Menendez told you on October 31st, 1989, before Lyle Menendez arrived at your office, would it be fair to say that your notes or summary of the statement go on from page 2 to page 6?
To part of page 6.
Okay. Can you approximate how long a period of time that was?
I believe it was something like 3 hours.
Now,
Oh, I'm sorry. You're asking me which period of time?
the
From
period
what
of
to
time
what?
from when Eric Menendez told you that he and his brother had killed their parents to the time that Lyle Menendez arrived at your office.
Okay. That wouldn't be 3 hours. That would be substantially less time. Maybe an hour, something like that.
Now, during this period of time, Eric Menendez has told you that he felt very guilty and he wanted to talk to you, correct?
That's correct.
And Lyle Menendez was not there, correct?
No, he was not.
So he felt free to talk to you at that point.
Objection, Your Honor, calls for speculation.
Sustained.
You indicated that after Lyle Menendez came, Eric Menendez became more quiet about what had happened, correct?
That's correct.
Does that mean that before Lyle Menendez came, that he was talking to you freely?
A same objection, Your Honor. More of a counsel meeting.
Overruled.
He was talking to me much more freely before Lyle entered the room.
After he told you about this BBC movie and how he and his brother, that was like the catalyst of the
Objection,
conversations.
Your Honor, that's misstating the evidence.
All right, without editorializing, just ask the question, Mr. Kuriyama.
The first conversation that took place about between the brothers, according to Eric Menendez, was after they had discussed this movie that they were seeing on BBC. Is that correct?
Could you repeat the question, Mr. Kuriyama?
I think the questions are anything else.
Overruled.
Is it your understanding, according to what Eric Menendez told you, that the first time that the brothers had spoken about killing their father in particular, it was upon watching this movie on BBC? Is that correct?
Yes.
Now, after that, there was some, as you've indicated, other conversations about the particular planning of how they would do the killings. Is that correct?
That's correct.
And directing your attention to page 3, after referring to the movie and the conversation that Eric related to you about he and Lyle planning to kill their father, what conversation took place as far as what they did after the movie? What discussions took place?
Between the two of them after the movie?
Yes.
Well, if you're talking about you're talking about when they came back into the, I guess I'm not sure which
Why don't
point
you
you're.
ask the question
Yes,
another
yeah.
way?
After the movie that they had seen on this BBC,
Oh, I see. I'm sorry.
Well, still let him ask the question.
Okay.
was there a discussion that he related to you?
Yes.
What was that?
Objection, this is beyond the scope.
Overruled.
The discussion that he related to me is that that they began to have a series of discussions that related to how to form the plan such that the murder could be executed in such a way so as not to be detected. And it wasn't any one discussion they had at one point. I think that
Okay, you've answered the question. Your next question, please.
Thank you, Your Honor. You indicated that it was kind of an ongoing process, the discussions that they had about killing their father in particular, correct?
Well, that was my understanding. Yes, that's what that's what I recall Eric having described.
And the discussions had been ongoing, and you indicated that the plan had changed.
That's correct.
Overall.
I don't know that the actual plan had changed. I think that the issue.
Okay, you've answered the question
Okay.
then.
Did you indicate that there were discussions between the brothers about whether or not they would include their mother in the plan to kill the father?
I'm going to object. All of this is beyond the scope of the law.
All right, is this discussion that you're asking about that occurred before going to acquire the firearms?
Yes, Your Honor.
All right, the objection overruled.
Thank you.
Yes, that's correct.
The discussions about whether or not to kill the mother as well included, according to Eric Menendez, what sort of consideration?
Your Honor, I'm going to object again. This is beyond the scope.
Can we specify when it is that this
This is
conversation?
before the actual purchase of the
Well,
shotguns.
Your Honor, that's
All right,
counsel
then
testimony.
why don't you ask it that way, Mr. Kuriyama, so we understand what the question is?
Dr. Oziel, prior to when Eric Menendez indicated to you that he went down to San Diego to purchase the shotguns, did he indicate to you that there was a discussion of planning that took place after the movie and before the purchase of the shotguns, which included whether or not to include the mother in the plan?
I would say more accurately that Eric told me simply that there had been an ongoing consideration back and forth whether to include the mother in the plan or not, and it had changed back and forth. But I couldn't tell you at what point the conversation was when they purchased the shotguns. I mean, I don't know how much of it the back and forth had to do with the time before the purchase of the shotguns and how much of it took place after the purchase of the shotguns.
Your Honor, I do strike the answer then because it's not beyond the scope, given that.
Well, part of it is not, so the objection is overruled.
Now, at one point, Eric Menendez indicated to you that they went down and bought shotguns in San Diego. Is that correct?
That's correct.
At that point, did he tell you that the police did not know where the shotguns were purchased?
I believe at that point what he told me is he didn't believe that the police knew about any of it, including, he didn't specifically tell me they don't know where the shotguns were purchased. He just relayed to me that he didn't believe the police knew about any of it.
Motion to strike.
Objection overruled.
Did Eric Menendez indicate to you that when they went to purchase the shotguns in San Diego that they used false identification?
He did.
Did you know from anywhere else that the shotguns had not been found other than through Eric Menendez?
No.
Now, you indicated that Eric Menendez on October 31st in cross-examination did not specifically himself threaten you. Is that correct?
Yes, he at no time verbally threatened me.
Did you feel threatened by Eric Menendez on October 31st?
Yes, I felt threatened with respect to Eric on October 31st.
Now, would it be fair to say that, as you've testified, Eric Menendez had told you that he had planned the murder with his brother?
Objection, Your Honor, this is leading accumulated.
Well, on the grounds it's leading, the objection is sustained.
I'll ask you, Dr. Oziel, why is it that you felt threatened by Eric Menendez on October 31st?
I think it would be difficult for me to answer that.
I'm going to object to any further answer by the witness, Your Honor, at this point.
All right, then you're agreeing that the prosecution can ask a leading question in this regard. Is that right?
Well, if you ask me to focus.
All right. Okay, you may ask a leading question then, Mr. Kuriyama, to deal with the subject.
Dr. Oziel, what are the factors or what are the things that led you to the conclusion?
Why don't you go back to the question that was objected to by the defense and start over again?
Well, Your Honor, I'd like an offer of proof to see if Mr. Kuriyama knows what the answer.
No, let's go back.
Dr. Oziel, you've indicated that you felt threatened by Eric Menendez on October 31st, correct?
I think I would state that, yes, I was feeling threatened with respect to Eric at different points in the October 31st session. I think it would be overly simplistic and inaccurate to state that the entire time that Eric was there that I felt threatened by Eric. That's not true.
At some point during that session of October 31st, 1989, you did feel threatened.
That's correct.
Okay. Can you in any way pinpoint when that occurred?
I think it was an evolving feeling. I don't think that it occurred at one moment.
Now, on cross-examination, counsel indicated that you were seeing Eric Menendez because of the Calabasas burglary. Is that correct?
Well, that was originally the presenting stimulus to why Eric came into treatment. That wasn't necessarily the focus of the treatment. That was initially.
Under privilege. Say anything more about
All right, the objection is overruled. The answer will stand as it is in the record. Your next question, please.
Thank you, Your Honor. Now, you indicated in cross-examination that on October 31st, you were afraid that Eric Menendez might break into your house and you had some paperwork in the house. Is that correct?
Well, I was fearful that Eric and Lyle together might break into my house, not Eric specifically.
Getting back to your feeling of being threatened by Eric Menendez, what else is it out of that conversation on October 31st that led you to that conclusion?
It would be very difficult for me to respond to this in an accurate way without dealing with.
Objection, Your Honor. May we please approach?
All right, you may. All right, your next question, please.
Thank you, Your Honor. Dr. Oziel, after Eric Menendez had told you that he and his brother planned the killing of their parents, and in executing that plan, drove down to San Diego to purchase shotguns using false identification, that they had an alibi lined up, that they surprised their parents in the room, and in particular, they killed their mother because she was a witness. Did any of those things that he had told you, did any of those things have an impact on you as to your feeling threatened by Eric Menendez?
I think that the feelings of threat that I had at that time were really affected by those things that you just mentioned and a lot of other things. I think it would be overly simplified to say that the feelings of threat came from one statement or one source or one issue. It just really wasn't that way.
Okay. Were the things that I've just related, just those items,
Components.
did they form part of the reason for your feeling threatened?
Yes, they formed part of it.
Okay, and indeed you had indicated or testified that Eric Menendez had told you how perfectly they had done the crime, that no one knew where the shotgun had been purchased, they used false identification, no one saw anything or heard anything, correct?
That's correct.
Now, after those statements were made and Lyle Menendez arrived, as on cross-examination, Ms. Abramson brought out, that Lyle arrived and was telling Eric Menendez how stupid he was for telling you.
Objection,
correct?
Your Honor, that's not the testimony.
Objection overruled.
Well, he didn't say that Eric was stupid. I think he said it was very stupid that Eric told me.
And what else did he say?
Objection, hearsay.
Overruled.
He said a lot of things. He said that, Lyle said, that now they could never feel safe again, or he couldn't feel safe again, that he would never be able to feel safe again, that there was no way to know I wouldn't tell someone, confidentially tip them or somehow or other let out the information, that he didn't want anybody looking over his shoulder. That's the reason that he killed his parents to begin with. He said that this was very, very bad. It made him extremely unhappy, very unhappy. He was repeating that as he was pacing, and he didn't know what he was going to have to do about this. There were just a whole lot of statements that were made, and in a menacing fashion, some portion of the time with Lyle pacing and having a very intense, threatening and menacing look on his face. It was very clear to me from.
Objection, I think he answered the question.
Okay.
All right, the objection is sustained. Your next question, please.
Now, based on all of that, you felt threatened, I take it.
Yes, I did.
Now, after Eric left the room, did Lyle tell you what he was going to do after that, after Eric left?
Well, we had a discussion after that. Is that what you're?
Yes. What did you say?
Well,
Your Honor, I'm going to object unless this has been brought out in cross-examination.
This is after Lyle Menendez has left and what Eric Menendez has told.
After Eric Menendez has left. And this is a statement that was brought out in cross-examination, I believe.
Okay, objection overruled.
Thank you.
I was trying to persuade Lyle to come back into the session, feeling very strongly that if the,
Objection as to the witness's feelings. He was
Okay.
asked what was
All right,
said.
objection sustained.
okay, I told Lyle that I thought that it was very important for them to come back into the session and try to resolve this, and that I was extremely uncomfortable and felt threatened by what had happened, and that I thought we needed to come back in and resolve this that night, and to get Eric and bring him back in and resolve what had just occurred in the session, namely.
Objection, hearsay. I think what was asked is what did Lyle say, not.
Objection overruled. Had you finished?
No.
All right, you may proceed.
Sorry, Your Honor. Lyle's response to that was that, no, he just wanted to go talk to his little brother, number one. And number two, that he wasn't sure that he wanted to ever talk to me anymore at all, or words to that effect, which to me were chilling words.
Objection as to his interpretation.
Objection sustained.
Okay.
After this exchange, you went down and you saw Eric and Lyle Menendez in Eric Menendez's Jeep.
That's correct.
And there was an exchange between you and Eric Menendez at the Jeep.
Objection
No.
mistakes the other.
No, it wasn't.
So after,
By the way, Your Honor, I should let you know that I'm going to need a bathroom break in a minute.
Okay, all right.
after Eric and Lyle Menendez left, that's when you started to make the calls, correct?
That's correct.
And you felt threatened by both of the brothers. Is that fair to say?
Yes, that is fair to say.
Now, on cross-examination, you were asked a question referring you to page 5 of the notes.
How much longer do you have, Mr. Kuriyama?
Probably 15 minutes, Your Honor.
15 more minutes. Okay. Oh, and as far as the recross so far, how much more would you have?
Nothing yet.
Okay. Well, we're going to keep going, ladies and gentlemen. I want to finish this witness today. I think everyone would agree that that would be appropriate. So we'll take a brief break, let the witness take care of his personal needs, and we'll resume at 1:45. Don't discuss this case with anyone. Don't form any opinions about it. We'll resume at 1:45, which is about 9 minutes from now.
Dr. Oziel, with respect to the questioning that was done in cross-examination about these logs that you have from September of 88 to August 20th of 89, the
Yes.
billing records.
Yes.
Now, you indicated that you had several sessions with Eric Menendez, correct, during that period of time?
I had more than several.
Okay, you had many sessions.
A series of sessions, yes.
Now, you indicated that sometime after November 2nd, 1989, you took the notes that you had and you destroyed them. Is that right?
That's correct.
Now,
The physical notes.
the paper.
The paper itself, yes.
And sometime shortly thereafter, you dictated the notes summarizing what were on those notes?
Yes, what I actually did is in going over the notes, I had a cryptic piece of paper where I logged the sessions that I thought were critical and made cryptic notes that didn't refer to anything that would identify anyone specifically, just to refresh my memory about each session, the content of it, and then dictated very shortly afterwards into the tape recorder what the content of the session notes were, having just read them, and then I just dictated them onto the tape so that they wouldn't be in a written form, such that anybody could actually just read them and see them, and because I thought that the notes shouldn't be read.
Objection as to what you thought, Your Honor.
The last part is stricken as non-responsive. You may ask your next question.
Thank you, Your Honor. For some reason, did you think that those notes should not be read?
Objection, Your Honor.
What's the objection?
Well, the court knows what the objection is to questions like that. For some reason, we thought, it's
Well, what is the objection? Is legal grounds for it?
privilege.
Why don't you rephrase the question?
Why is it that you got rid of the paper or the notes that were written on these papers?
Your Honor, I'm going to object on the same basis.
Overruled.
I thought it was very important that no one be able to visually see the actual data that related to the sessions that I had had up to that point with any member of the Menendez family.
Dr. Oziel, do you recall putting the notes then on audio tapes?
Yes, I did put them on an audio tape.
Okay, was it one audio tape that contained the summaries of the sessions that occurred between September 1988 and August of 1989?
Yes, I believe that I just summarized the sessions on audio tape. It may even have been the same audio tape as I subsequently recorded these sessions on. I don't recall, but I did put them on audio tape.
With respect to that audio tape, what did you do with it?
I put that audio tape in my safe.
Is that the safe that you had at home?
Yes, the one at home.
Did that particular audio cassette tape end up somewhere else?
Ultimately, it did. Yes.
Where did it end up?
Safety deposit box.
Okay, when the Beverly Hills Police Department did a search warrant on your house, was that particular tape among the other tapes that you had done regarding the Menendezes?
Yes, it was.
Were those tapes also seized along with the tape that you've testified to regarding the October 31st, 1989 and November 2nd, 1989 sessions?
That's correct. It was seized.
Was that particular tape part of the hearings that occurred in Santa Monica
Objection, Your
in
Honor.
June?
That's irrelevant and invades 1024.
Objection sustained.
You don't have those tapes anymore, is that correct?
I do not.
Any of them?
I don't have any of the tapes.
Regarding the hearings that took place in Santa Monica Court,
Objection, Your Honor.
in-
Irrelevant and invades 1024.
We haven't heard the question yet. Objection overruled.
thank you, Your Honor. On June 15th of 1990, counsel read from a transcript from those proceedings. At page 36 on that date, she read you a portion in which you stated, I concluded that they had basically a perfect situation where no one would discover them. That was read to you just shortly before we took the break
That's correct.
by the defense attorney, correct?
That's correct.
Now, when you testified in that fashion in Santa Monica Superior Court, what did you mean by that? That you concluded? What did you base that conclusion on?
Well, I based it on a combination of what was stated to me in the 1031 session and then my own conclusion about the data that I had received from first Eric and then by adoption Lyle.
And did that include the conversation that the brothers themselves used or words that they themselves used that they did the perfect murder?
Yes, Eric used that phrase and Lyle used that phrase in the 1031 session.
You were asked on cross-examination about a statement as reflected on page 5 of your notes. It's the middle paragraph on that page. And this is out of the October 31st, 1989 session.
Yes.
That Eric had more and more difficulty dealing with the fact that they were going to be inheriting a great deal of money, probably in the neighborhood of $15 million. Is that correct?
That's correct.
At that point, that is October 31st, 1989, he was having more and more difficulty with that. Is that correct?
Yes, he was.
Now, I'm going to direct your attention to page 19 of the transcript that you have before you. This being toward the end of the November 2nd session. And direct you to the second paragraph, the last sentence.
Yes.
Would you read that last sentence?
I'm going to object to that as beyond the scope because that was dealt with because of both juries.
Objection sustained.
Did Eric Menendez ever tell you,
And I'm going to
What-
object.
We haven't heard the question yet.
did Eric Menendez ever tell you what he was thinking about the money situation before he committed the murder?
No.
That is,
I
on
think the question's
November-
been answered, Your
All
Honor.
right, the question is vague. The answer is stricken. Re-ask the question.
Thank you, Your Honor. On November 2nd, 1989, did Eric Menendez tell you what his state of mind was with respect to money before he committed the killings?
I don't believe that that's what that statement relates to. I believe that that statement,
Well, I'm going to object, Your Honor, because the witness now is referring to a statement that's already been examined before both juries. So.
All right, the objection is that this is beyond the scope of the cross-examination that is occurring at this stage before this jury, and the objection is sustained. This was something that was covered earlier and was not subject to the cross-examination by Ms. Abramson before this jury.
Dr. Oziel, was there a statement about an inheritance?
Objection, Your Honor.
And what conversation are you referring to?
Your Honor, I'm referring to the November 2nd conversation. I just want to clarify, and this is my last question. And I will be done with redirect examination.
Same objection, Your Honor.
All right, well, it'll be the same ruling then, Ms. Abramson, as I did with you when you said it was going to be the last question. Objection is,
Anything on the last question?
at 5 o'clock or 5:01 on Wednesday, the 11th of August, 1993, yes. All right, so you may ask the question, Mr.
Thank you, Your
Carrion.
Honor.
I get the question.
No.
Dr. Oziel, referring to page 19 again, did Eric Menendez indicate to you anything about an inheritance as a reason for getting rid of his father? The last
I'm hesitating
sentence.
because I'm trying to determine whether I can answer the question the way that you asked it.
Well, why don't you ask it, let's have the question read back first, start with that. This being the last question.
By the prosecution.
Question, Dr. Oziel, referring to page 19 again, did Eric Menendez indicate to you anything about an inheritance as a reason for getting rid of his father?
Well, let me clarify and state that he recounted a memory of what how his father had behaved with respect to threatening to disinherit him as an indication of how extreme and unreasonable his father was. And he did state that that was an example of what contributed to or evidence of his need to kill his father. That would be correct.
No further questions, Your Honor.
All right, is this the, a question that you want to ask, or you just want to get in the last word? Which is it, Ms. Abramson?
Your Honor, I'm so tired right now that I'd be more than happy to go home, but I think I have to ask just a couple of questions.
All right, within the scope of the examination by the prosecution, you have the opportunity to ask 2 questions.
Thank you very much, Your Honor. Dr. Oziel, let's stay with that same topic. Eric was not telling you, and in what you've related here on page 19, that he killed his father because he nearly disinherited him, was he?
No, I don't believe he was.
He was trying to tell you that his father's threat to disinherit him at some time in the past was an example of his father's extreme erratic behavior.
That is correct.
Now, it's true, is it not, Dr. Oziel, that in these notes of the section of the session of October 31st, before Lyle got there, you do not specifically say that Eric told you there were a series of conversations and discussions leading up to a decision to kill the parents?
It is correct. In the notes, I do not say that.
And it is also correct, is it not, in the notes, there is no delineation of a plan.
Well, I don't know what you mean by delineation.
Okay. You've said that they discussed planning, they discussed killing, but you don't lay out in these notes what the plan was.
All right, that is beyond the scope of the cross.
No, the council
Or
asked about the
redirect,
details of the
rather.
plan.
Well, they didn't ask the details of the plan in their entirety, only a specific portion of it related prior to the trip to San Diego to purchase the guns.
Okay, well, but let's focus on that then. Let me just focus you on this. Physically, in these notes, references made to the I'm sorry, let me just focus on where they are. Okay. Let me call your attention to page 3. Yeah, you need to know.
I have it.
Thank you. Physically in the notes, the way the notes are dictated, the reference to going to San Diego and purchasing guns is on the bottom of page 3.
That's correct.
Okay. Prior to that in the notes, is there any delineation of any aspect of a plan?
I don't know what you would consider a plan.
Well, but is there anything in here that talks about a plan to kill? I think you said the plan was a plan to kill in such a way as to escape detection. Do you see anything relating to that in these notes prior to that point?
I don't see anything in the notes that specifically delineates a plan up to this point in the notes.
Okay. Now, after that point in the notes, is any description having to do with the plan, such as buying the guns, having an alibi, going into the room with their parents, or is that all contained in that very same paragraph as going to San Diego and buying the guns, the bottom of page 3?
Not everything that was said to me is contained in that paragraph, but the things that do relate to the plan that are included in the notes for this session, I believe, are primarily contained in this paragraph.
So that's
The
the
objection is to the answer is non-responsive. The objection is sustained, and also the question is actually beyond the scope of the people's redirect. So the court sustains the objection to the
Okay.
question as well.
So let me see if I understand. Prior to any mention of San Diego, there is really no indication in the notes about ongoing discussions involving planning. Is that correct?
Well, it does state that he and Lyle had tossed back and forth the notion of how their lives wouldn't be living.
Right.
It does. I mean, there are elements that one could state related to the plan, but it doesn't specifically mention the word plan or detail a plan prior to that point in the notes.
Well, it talks about basically motive, that their life wouldn't be worth living, but it doesn't talk about plan. Isn't that true?
Well, it talks about the show, and in Eric's talking about the show, Eric discussed some things that related to the plan, but he did not elaborate his plan with Lyle at the point that he talked about the show.
Okay, and I think you've already testified previously in front of this jury about, in front of both juries, in fact, about what you meant by plan. Is that correct?
All right, that's been asked and answered. Go on to something else.
Now, you said you put the tape that you made of the extraction from the written notes in the safe in your house, right?
Best of my recollection,
And that's where you put the tape of October 31st and November 2nd as well, correct?
to the best of my recollection.
And you
yes.
had both of those tapes duplicated, numerous copies.
Yes, I did.
Okay. So when the police went to the safe deposit box, there were a lot of separate cassettes.
Yes, there were.
In any of this discussion that you had with Eric and Lyle about the perfect murder that you've just testified to, did you bring up the fact that they had not really buried the guns, but just sort of
Yeah,
dumped them
objection beyond the scope.
as an imperfection?
Objection sustained.
Did they bring up in talking about perfect the fact that they had dumped the guns?
Objection beyond the scope.
Overruled.
Can you be specific about which discussion?
Well, either on October 31st or November 2nd, did either Eric or Lyle bring up the fact that dumping the guns made the plan perfect?
Made it perfect or made it imperfect?
Perfect.
They thought that getting rid of the guns was made it perfect, but they didn't think that they had perfectly buried the guns or gotten rid of the guns. They felt they still needed to in a more effective or efficient way, get rid of the guns.
And isn't it true, Dr. Oziel, that you offered them suggestions on how to do that?
No, actually, that's not true.
You didn't tell them the ocean is better than lying on a hillside. Is that your testimony?
No, actually, that's not true. I didn't say that, to the
Nothing
best of my
further.
recollection.
Nothing further.
All right, anything else?
No, Your Honor.
All right, thank you. You may step down. You're excused, subject to being recalled, Dr. Oziel. And as far as the jury is concerned, we'll see you back here tomorrow at 9 o'clock. Don't discuss this case with anyone. Don't look at any of the news coverage and don't form any final opinions about it. We'll see you all back here at 9 o'clock. I guess you go next door.